3 of the Federal Amendment 1934 and read Section 3 of the Prevention of Damages to Public Property Act 1984 for exceeding the year number 193/2023. The petitioner really refers to scope or his bail in such and such cases. But usually case very for his period in bail in AB 1408206 requested by an order dated 30/06/2022 and said in the derivation of the matter is such as applies before on instruction applies before that the said before the police after investigating the matter has already submitted the charge sheet by charge sheet number 143/2023 on 29/07/2022. Very the petitioner name petitioner is found to be according to petitioner. Okay. Yes, next.
Much obliged, Lordship.
Yes.
Lordship, this is the instruction. I've also received paragraphs from Lordship. May issue notice short date.
We'll do it.
One was it apply Lordship, the instruction doesn't say whether he is entitled or not, whether given or not. Let me take a complete instruction on that regard. That intention is not forthcoming from the instruction.
So whatever is written here,
Lordship,
whatever is available here is just like a boss.
it just says that he has not applied.
Whatever, just like a boss, but not that way. If he is entitled, after all, whatever is from his salary, right?
Whether they want to take the delay point or
he cannot, they cannot. The laws are well settled in that regard. Ask them to
just say in simple word whether he is entitled or not.
Now, if entitled, it should have the offer should have come from them. After all, yes, from his salary it was deducted.
That's true, Lordship.
That kind of bossism is difficult, you know. But Mr. M.K. Sharma, counsel appearing for the petitioner, and Mr. B. Chakraborty, Lanet CGC, for the response number 1 to 7. Issue notice returnable by 6/6. As such and such no problem. Petitioner shall have requisite extra copies. Pendency of this petition shall not be a bar for the responding authorities to consider, release and pay the amount of GPF and JS as per his entitlement.
The judgment which are that appointment of endeavors have been made for disposal of
Later.
my.
All right, take it.
Yeah, please, Your Lordship. The conducting counsel is out of station. The conducting counsel is out of station.
Counsel, where is he?
He went out of
You
station.
appear. What's the matter about?
I'm not aware of the text.
Microphone on for it. Who is appearing for IOCL?
Actually, we are given the adjournment slippers. Yes, sir. Yes, sir.
Today we conduct the constitution. Instructions. Mr. Bora, whether he was arrested?
No, he was not.
Where is the suspension order, Mr. Sir?
Yes.
Annexure 9,
Case 59.
case 59.
Mr. Bora,
Your Lordship.
why these things are happening? Why?
I've been told that final order, because the DC has just recently
See,
joined.
the person concerned, the deputy commissioners have to move from one place to another, right? But he is not the main person there. There are other officials
I
who
understand.
looks after this. What action have been taken against those people?
That's what, since the DC has recently joined, I've been told,
We have nothing to
she is
do.
going to take in some decision on the disciplinary proceedings.
There is someone in the personnel branch of the deputy commissioner.
I understand, Your Lordship.
Then, so basically, one thing is there. The man was in place under suspension on 6th of April 2022 for the work that he has done. It will come out in the DP. DP was initiated, if you pay 60,
Lordship.
on 28th of September. So that period is already over in September, June.
Your Lordship.
July.
July
So
26.
till now, without extracting any service from this man, from public exchequer, he has been paying 75% of salary. At whose fault? Could have put him somewhere else because the fee was for salary.
Your Lordship.
These are the things. No,
In fact, I also inquired regarding the.
we are not passing any order. We are just fixing it.
Your Lordship.
We are not passing any order.
Your Lordship.
We'll see what you do. We are fixing it on 15th. Let us see what you do. This time has been given so that the deputy commissioner can revive all our department, wherever is there.
Understood.
Find out how many cases of business are pending, what is the issue, right? Let us
Understand.
apprise her correctly, what is the wrong. She may not be aware. We have to consider 40% list on this.
I pay for 3, 4, and 5.
One and
I have received the instruction. Total 27 numbers of teachers are there, my lord. So PTR ratio is 1:29. And as regards the seniority position, my lord, he is in 19. Graduate teacher 19, my lord, serial number. Only one junior teacher below to him, my lord. Serial number 20. She has recently joined, my lord.
Lordship, I have not received instruction.
Did I ask you? Who did not ask you anything? You have a copy of this
Yes, my lord.
for a contractual teacher. B.Ed degree is not required.
Otherwise required, my lord.
Then how they are serving? Last two.
Last 21 and 22, my lord.
Not 21, 22. 26, 27.
Yes, my lord.
That day we have passed an order where Ms. Musahari was there. You have this book with you? You have this book with you?
Yes, my lord.
Yeah. New book.
Yes, new book only regarding policy this act transfer act supplementary.
So small.
Because recent act and rules and other notifications of there basically a supplement to the
Main book.
main book
Okay. More. One page. Now, please come to Assam Elementary and Secondary School Teachers Regulations Posting Transfer.
the regulation and posting of transfer.
2020 Act.
Yes, rules 2020
The Act.
act
2020 Act.
act
Regulation of posting and transfer.
yes
That will be applicable in this case, right?
yes
Now, read the act, the first paragraph. Madam, please take your seat. Madam, you take your seat. It starts with to provide for. Got it?
here this in this
Act, give the act, read the act.
act is not available in this act is not available. Yes madam.
You read it? Just read.
To provide for the responsibility of the state government to manage posting and transfer of teachers of elementary and secondary schools according to the requirement of teachers in a school in order to maintain proper pupil-teacher ratio.
Now, preamble is there.
Yes, madam.
That's where ratio has to be maintained. Now, definition 2,
Yes, ma'am.
read B.
Category or cadre means different category of teachers working in the state like principal, vice principal, headmaster, assistant teachers, intermediate teachers, graduate teachers, postgraduate teachers, fixed pay teachers, contractual teachers, additional teachers, craft teachers, music teachers, tutor, etc.
Come to definition, next page. Teacher, P.
Teachers means all teachers or tutors of both elementary and secondary schools drawing salary or fixed pay or honorarium from the government, exchequers or from the Samagra Shiksha Abhiyan, Assam, excluding heads of school.
So it includes the contractual teachers also,
Yes, yes,
right?
yes,
In that case, petitioner is much above,
yes, madam.
then you can understand. The policy is yours.
Yes,
You have to follow it.
yes, madam.
And that policy comes because there is no such rules. That is why I have issued the office memorandum to follow that office memorandum.
Yes, madam.
Now, one more issue is what we have found here. We come to the uh, 2018 rules, some secondary.
Yes, madam.
Now, there you just see one thing. Come to Rule 13. Rule 13(2)B,
He must have at least 10 years of
A and
teaching.
B both, right?
He must be MA, MSc, MCom from any recognized university. Then he must have at least 10 years of teaching experience as postgraduate teachers or 12 years of teaching experience as graduate teachers in a higher secondary school.
So he is because one more thing, this is not an amalgamated higher secondary school. The seniority will be counted from database.
Yes.
So he is at serial number 19. There are juniors to him. Serial number 20. Then you have,
Other contractual teachers, madam.
doesn't matter because the teacher definition under the 2020 Act includes everyone. So, you know the ritual. We pass a detail order, third MSD data. Counsel appearing for the petitioner. And Mr. N.J. Katani, learned standing counsel, Department of School Education. Audit respondent numbers 1, 2, and 4. Ms. Such and such. Standing counsel AGA Assam, audit respondent number 3. Mr. B. Devi, Government Advocate Assam, audit respondent number 5. And Mr. A. Saliha, standing counsel finance, audit respondent number 6. Pursuant to the order dated 28/08/2023, Mr. Katania, the inspector of schools Nalbari have placed, through Mr. Katania have placed the communication dated 31/08/2023 to show the number of enrollments in the Korea Higher Secondary School District Nalbari, which reflects that there are altogether 719 enrollments in the year 2023-2024, with 27 teachers in position at the ratio of 1:29. Further, the seniority list of teachers serving in said Korea Higher Secondary School of District Nalbari, it is reflected that petitioner's seniority position is at 19, whereas below him there are one general graduate teacher, one graduate teacher, and two contractual graduate teachers. बाकी की नहीं पढ़ाई अब ऐसे ऑर्डर से सारे मेमोरी से according this will notice returnable by (2709). Petitioner shall require extra copies of such and such during the course of the day, obtaining necessary acknowledgement till the returnable date. The interim order passed earlier on 28/08/2023 shall remain in force. The instructions committed by the Inspector of Schools Nalbari, placed before the court by Mr. Katanil and standing counsel department, will be kept as a part of the record.
Lord, this item may culminate in Act 2, my lord, some problem. Act 2.
So I'm appearing for the respondent here as some plaintiff corporation. I was informed by the petitioner side that they would like to withdraw this matter.
Yes, he also informed me just now that we will withdraw. Because, oh,
Let us wait for some time.
Yes, sir.
If he comes.
She is here, she is here. Officially.
Yes, Mr. Noel.
Mala want to withdraw the case petition, my lord.
Third,
Yeah.
this dishonorable counsel query for the petition. Mr. Ard Hall, petition for Assam for the restaurant number 1, 2, and 4. Mr. A. Sriha, standing counsel finance for the restaurant number 3. And Mr. A. Sharma, standing counsel Assam Plains Tribes Development Corporation, restaurant number 5. During the deliberation of the matter, Ms. Sonwal, on instruction of the petitioner, raised for withdrawal of this petition. Prayer of petition to dismiss.
Well, liberty to
Delivered to file special as an interest for the petitioner.
While filing the case, they may serve copies upon us. We have no copies this time also. Obliged.
Mr. Sharma, one thing, have you, whether the corporation has notified to the registry?
Yes, we have done that. We have written to them. Yet I do not know why it's happening sometimes regarding this corporation.
No, it needs to be notified, that's why.
Yes, no, that we have done also. Obliged.
Yes, Mr. Sakia.
May I please, so the petitioner before us, she is the widow of the my lord, army personnel, my lord, who served in the my lord, Indian Army in the EME Corps as EME Corps, my lord. So, my lord, after the demise of the my lord, her husband, my lord, she was getting family pension. Now, my lord, from March 2023, suddenly, my lord, her family pension has been stopped without any.
Get a CGC. You pass the order, get a CGC. Anyone? Mr. Chakraborty or whoever. The Chakraborty as Timothy,
Well,
Gogo, whoever it is, get it at CGC. Yes, Mr. Karan.
In this case, Milord, I have challenged the amount to order of suspension, Milord. The facts of this case, Milord, the petitioner, Milord, was the headmaster of an LP school, that is Pathimari LP school. Then, Milord, in 2021, services of Milord, Pathimari ME Madrasa, Milord, were provincialized, including the response number 5, Milord. Then, Milord, it was directed to Milord Mars with the petitioner's school. Then the response number 5, neither Milord handed over the charge, nor he attended the school. So the matter was informed to the authority. Then Milord, some students organization, Milord, is said to have filed an application before the DO, then the honorable minister, and accordingly Milord, inquiry was conducted, and the report was submitted behind that of the petitioner. And then Milord, suspension order was passed 1/8/2023, that is page 46. Page 46, the order of suspension.
Where is the amalgamation order?
That is not amalgamation, Milord. It was March.
Where is
March.
it?
That is page 29, Milord. That order of compensation of person number 5, and in the right hand side, 8884 number Pathimari LP school, it will be the base school. And clause number 2, Milord. And the school was Pathimari ME Madrasa, and it should be matched with the base school Pathimari LP school.
Yes, then.
Then page 46, the order of suspension. It is the revision of so and so, and the hearing report submitted by the DO, letter number so and so. That report was not furnished to the petitioner. Also, produce the information was submitted by the DO, so and so, letter number so and so. In view of the above information report as mentioned herein above, and pending developmental proceeding, so and so, that is the petitioner Miller, so LP school, under the office of the so and so is hereby placed under suspension with immediate effect. Immediately thereafter, Miller file an appeal. Institute appeal under Section Rule 14 of the Assam Family Disciplinary Appeal Rules 124/5/2023, page 47, Miller. Then Miller, within 90 days, Miller, it was not reviewed, what Miller, that suspension order was not extended. Then Miller, by to order dated Miller 87 to 23 page 54. Charge was framed, and petitioner was asked to submit his written statement. Page 54 . In the charge report, Loshimi Kalitan to go for paragraph 1, what is the charge? That while you were serving as head teacher of so and school under Sangapore District of District, various allegations, complaints were raised from the local public as well as Procedural Students Association that you were involved in practicing financial anomalies as regards to the school grants, regular attendance in classes, etc. You were also asked by the BO Sangha to produce the accounts released, reports and so pertaining to the school, but you had neither produced the reports nor appeared personally in the office of the BO Sangha. You are therefore charged with the violation of the government so in this violation of Rule 3 of the Assam Service Conduct Rules 1965. The petitioner filed his written statement 1,24,723, page 56. So my case is that it is violation of this case within it should not be extended beyond 3 months, and my appeal has not been considered disposed of.
Standing council elementary.
And as per rule 24, the appeal should be to be have been disposed within period of 3 months.
Who is heading the education department among the standing councils? Who is heading? Who is heading the standing council education?
In our,
You have a sets of standing councils.
yes, madam.
How many?
We have around 30 altogether.
Altogether 30. Who is heading?
But we have some, there's an allotment in respect of each of the council, madam. And the allotment was given by Mr. Sisti, madam.
Ask Mr. Sisti to meet me at chamber 1 o'clock.
I'm dealing upon the other service, other commercial cases.
Yes, Mr. Sharma,
Lordship.
let us know whether review was done or not.
Lordship. Even 92 lordship. And apparently there is an appeal also pending.
My appeal also
28.
pending.
20. List on 28, Honorable Mr. Sharma, Standing Council Elementary. One on. Place the court as to whether the suspension order of the petition, order of suspension of the petitioner from service.
Suspension
Has been reviewed
of 8 March.
by the Director of Elementary Education. So, when and the outcome of the same.
Probably. Yes.
Pardon, Mr. Aegis Cycle and Council appearing for the petition. And Mr. S. Committee and its CGC for the respondent numbers 1, 2, and 3.
May I take instruction on 6 and 19, my lord?
You want to do that?
Yeah,
List on
19 September, my lord.
online.
My lord.
Present such. And I believe Mr. Medir and its CGC to place the relevant instructions. Pendency of this petition shall not be about for the respondent authorities to release the family pension to the petitioner.
I have an interim prayer, my lord, for the provisional pension.
On that day, it will be considered, my lord.
Pujo Sandra Pantadas. Serving as what?
Serving as the Nayak.
Ex-Nayak of EME Corps.
My lord.
Having had a regimental number 3710-6572 and retired from service on 31/07/1986. From which station? Mr. Saika, from which station?
Nogam.
No,
Army station. You served in the as EME course, that is electronic and mechanical engineering.
but stations are different.
Yes, my lord. So I'll take instruction, my lord, 19 fix, my lord.
But whether the respondent number 2, principal controller of
Yes,
defense accounts,
yes.
they are the persons who are
Yes,
releasing the pension, my lord.
The extra copies to Mr. Mehdi during the process. 90 additional text of charge.
So far, provisional pension is concerned, because suddenly,
Let him get the
Yes,
instruction.
yes. I'll have it.
May I please, Your Lordship? Your Honor, we have filed this writ petition challenging the force order dated 21/7/23, force order number 24, Your Honor, whereby the petitioner is illegally transferred from his post of Alipurduar to Rongia, Your Honor. Earlier, we have also filed writ petition 4744/23. Your Honor, may kindly, I may take your attention to page number 55, Your Honor. Sorry, Your Honor, page number 64, Annexure 7, order dated 17/8/2023.
What is the order of transfer? What is the order of transfer?
Transfer, Your Honor, page number 14, Annexure 1, force order, 24, number 24. Your Honor, he is in serial number 42.
What is your name? Which page? That as per order, where is your name?
42 serial number, no? Page number 17, 42. Last part, Ramesh Chandra Roy. Your Honor, the petitioner's daughters, one is in class 10 standard, Your Honor, and one is in 7th standard. And they are studying in Bengali medium.
Get hold of Miss B. Devi, B. Sharma. She was appearing in your notice. Take it after some time.
Okay.
May I please, Your Lordship? My lord, this is an application for increment of opposite party number 1 and 2 as respondent number 6 and 7, my lord. The Lordship will find an order dated 12/6/2023, my lord, in the writ petition, my lord.
A.H. Chaudhary, right?
AHMR Chaudhary.
AHMR Chaudhary. Also representing and Mr. H. Ali Haq, standing counsel national education for the standing counsel health and family welfare and also for national education. For the respondent opposite party number 1, 2, 4, 5. As well as Mr. B. Devi, Government Advocate Assam, the opposite party number 3. The applicant has a petition filed a petition, mean WPC number 2245 of 2023. Presently pending for disposal. In a patent case, the applicant in the same petition failed to make the mission directive, National Health Mission, District Program Manager, National Health Mission, Morino, as party respondents. As this interlocutory application by the civil petitioner for implement of Mission Director, National Health Mission, Assam, as well as the District Program Manager, National Health Mission, Morino, as party respondent members. Six and 7. To which Mr. Chali Lani, counsel for the opposite parties have no objection. We have seen that the Mission Director, National Health Mission, Assam, as well as the District Program Manager, NHM Morino, necessary party, and say WBC number such and such for adjudication of the said case. for the prayer of the applicant during this interrogative petition for improvement of the party. Next it is IAC. In view of the order passed today in the connected IAC 2534 of the 2023, the mission director Roman AROB, mission director National Health and Health by Patent Place number 2 be implemented as party respondent numbers 5 and 6. Sorry, 6 and 7. The consent section of the registry shall accordingly corrected. Next day, Mr. A. Sullivan, the standing counsel, NHM has entered appearance on behalf of the newly implemented respondent numbers 6 and 7. Issue notice returnable by 4 weeks. Petitioner shall serve the sending copies to Mr. Sullivan during the course of the day of the incident. Register shall reflect the name of standing counsel NHM in the cause list against the citing for the respondent numbers 6 and 7, along with other advocates of the
Obliged.
The bank has filed an evicting application against the order dated 31/7/2023. You could see,
We have received the copies yesterday. If we may be allowed to file the objection.
but we have already disposed of their representation on merit firstly. Secondly, Lordship would see at page 25 is the
When
order.
did you file? Yesterday.
Yesterday they have cleared the defect. It was filed on 21.
No,
We received the copy yesterday. The record shows it was registered on yesterday, Lordship. We have received the copy also yesterday.
on 21/8, no? 21/8 we have filed it.
It was registered on yesterday, Lordship.
21/8 we filed it.
Yesterday.
Number, it is numbered yesterday, but it was filed earlier. On
There are some
21/8.
defects. It was returned only on yesterday.
Yes.
Yes, noted is that. The respondent bank of Baroda have filed this application. For vacation modification of the order dated 31/07/2023, passed earlier in the connected application number 4328/2023, stating that the representation of the petitioners have already been disposed of. It is seen from the records that this I has been filed and registered only on 31/08/2023. Though it was filed on 21/08/2023. On the prayer of Mr. D. Deka, learned counsel appearing for the opposite party numbers 1 and 2/8 petitions. Every time you can get the file, reply to this application. List on September 12th. The opposite party numbers 1 and 2 shall file its affidavit in reply upon an opposition if any on or before 7/08/09 serving a copy on the council for the respondent applicant. Yes, next.
Extend the interim order. Interim order.
In 2004, I have retired, my lord. I'm 79 years old, my lord. Till date, my lord, my pension has been withheld. So Lordship last occasion asked me to prepare a date chart, basic date chart, and also the fact that when the charge sheet was given in the criminal case, my lord, the charge sheet I have given, my lord. I have the certificate copy with me.
Extra copy of similar number.
You have gone through the provision of pension rules.
That's it.
So what will happen?
That's it. Because of criminal cases pending.
That's why I have asked you, have you gone through the pension rules? Have you
That's it.
gone through the pension rules?
That's it. Provisional pension, we are.
Read the rules properly, what the rules is. Mr. Chakraborty, there is a good judgment of justice.
I tried, my lordship mentioned it.
May not be, it may not have been reported, but it's very good. May not have been reported.
Yeah, I searched my face, my lord.
I read it, that's why I'm telling you. He has discussed many judgments. Somehow, if it is not reported, it's, I don't know.
No, I have given 3 judgments there, my lord. One by Justice M. Chaudhary, one by Justice B.K. Sharma, and one Supreme Court judgment, my lord.
No, in that case, okay. Because delay in initiating the proceeding after retirement.
No,
That's
proceeding has never been initiated in my case, my lord. Only a criminal case which was filed after my retirement. I have retired in 2004. 2005, an FIR was filed against me and 19 other officers regarding some scheme. Now, charge sheet has been filed on 2011, as I have given, my lord. The requirement is that.
Provisions was taken after 4 years of your retirement.
Yes, my lord. Now, as per the interpretation of the rule 21, it says that institution of a criminal case means when a charge sheet is filed and magistrate take cognizance. So after 2011, I have retired in 2004. So on that basis, that a criminal case is pending against me, they cannot hold my.
Read it.
That is the only point, my lord.
Read that provision in the pension rules. Rule 21.
21C.
Yes.
See, no such judicial proceeding, if not instituted while the officer was in service, whether before his retirement or during his re-employment, shall be instituted in respect of a cause of action which arose or an event which took place more than 4 years before such institution.
Hmm.
21
Proviso
B, Lordship. A judicial proceeding shall be deemed to be initiated in the case of a criminal proceeding on the date on which complaint or report of police officer on which the magistrate takes cognizance is made.
So here, that's why we asked Mr. Chakraborty to prepare the chart. So as per this, the petitioner retired from service when?
2004.
31st of January 2004.
That's it.
Now, when this FIR was launched?
2005.
September September, 27th of September 2005.
Lordship.
But when the cognizance was taken after filing this asset,
2009.
it was filed when? Mr. Chakraborty, what is the
T1,
date of the-
T1
that was the search sheet file?
Madam.
When the magistrate took cognizance of the offense.
Must be must after that, madam. That is not relevant because 4 years is gone by long back, madam.
So if you have seen in the search sheet was filed on 3rd of January 2011.
Lordship.
And as of date, we do not know whether search sheet cognizance was taken or not. But it doesn't matter.
Lordship,
So from January 2004,
Lordship.
only after search sheet was filed in 2011.
Lordship.
Can you stop his pensionary benefits? That is why even if you read the Rafiq Masa, you'll see there also their lordships considered these aspects.
Lordship.
Time limit,
Lordship.
anything processed after that period will not stop his entailment to the benefit, a pensionary benefit. So, in fact, there is a very good judgment of Justice Gogoi.
Yes, go.
There was a provision to initiate a disciplinary proceeding even after retirement. That's a very old rules on the basis of which the government of Assam continued to do it. It is available only in Northeast Regional Manual. I will not get it in the website also. There's a book.
Still go.
That is, the period is that 4 years. The government of Assam have accepted it 4 years. Beyond 4 years, anything will initiated, even in disciplinary proceeding or any criminal matters, with that clarified.
That is the rule, madam. Rule clearly mentioned, madam.
So, now tell us, man has retired in 2004.
My wife is suffering from cancer.
Now we are
So many
in
diseases, madam.
almost in the month of September, right? Last quarter.
Because of criminal proceeding.
That cannot be that rule, and that's rule you are reading is a 309 rule. It's a statutory rule. If you read the first provision, you will see it's a 309 rule. So it is not that as per your choice you are able to do it. You have to do it as per the rules. So being statutory rule, there may be a criminal proceeding. That will not be enough.
Lordship, I leave it to you.
Take instruction from the authority and pass the order on Wednesday. Next. Tell him, tell your
Lordship, kindly
authorities.
give 1 week time, Lordship.
You are getting it. Today is fast. You are fixing it on 13th. You are fixing it on 13th of September. On 13th of September, we pass the order.
6. Maybe 19, Lordship.
Why? Why on
That's it.
19?
Actually, I have some personal difficulty, Lordship. Only 1 week, Lordship.
Okay.
Next,
But on 19th,
Lordship.
we want to see action from your side,
Lordship.
not from you, from your department.
Lordship.
Provisions are there. These are
Okay.
statutory provisions.
Gotcha.
You cannot escape from that.
Lordship.
You have seen Mr. Chakraborty has given you the dates, right? So thereafter you cannot do it.
Lordship, I will do my
19th.
best.
Yes. Okay. Mr. Chakraborty, let's have it on 19th.
I'm going through a pathetic condition. Paragraph 9 I have mentioned, madam. He's 79 years old.
Agriculture department. Agriculture or PNRD?
Agriculture, Lordship.
For 1 and 2. You will also appear for 3 or somebody else will appear for 3?
1 and 3, Lordship.
1 and 3, Director of Agriculture, okay, 1 and 2. Mr. V. Handy, Standing Council PND for response number 3. Who will appear for AG?
I'm
Mr. S. K. Mehdi, Standing Council AG for response number. Who will be appearing for DRDA? You will appear? Okay. 3 and 5. Mr. B. Deori, Government Advocate Assam. For the response number 6. Mr. Chakraborty, what is UGSTC?
UGSTC. Ashik, refer to which page, madam?
Page number 16. As well as page 18. And then DOCC, page 20. You are serving as DOCC and TC at Sinsir. What is that? Page number 26A. 26A. District officer.
X, UCC and TC. I'll take instruction, madam. Substantive post, they say that it is instructor.
Initially it is instructor, but he probably retired as a DOCC and TA.
Yes.
Madam, you will be knowing, you are representing agriculture. Two things. One is APO. He was probably DOCC, AC, but he was shown as an APO.
Demonstration officer, Lordship. Demonstration officer, community, canning and training center, Silchar. Post last year hold, Lordship.
Demonstration officer, CC.
Community canning and training center, Silchar.
DRD, no?
but he deputed to DRDA sister as APO.
APO means
Assistant project.
demonstration officer,
Lordship.
community and canning.
Community and Canon. Lordship. Yes.
Station officer, community canning, and training center. So, as assistant project officer.
Assistant project.
Additional or assistant?
Assistant.
Assistant project officer in the district rural development authority. Agency. Acha. Deputed to live. Deputed as such and such.
PC Shilpa Tuti.
Retired from service from 3101. The age of 58 years, I think so. 2004
Retired.
probably 2004 should have been 58. That's come later on. 1 year it was 59 and then later it was 60.
50.
2004 I think it was 58. Till date. The respondents in the agricultural department of the state. Agriculture department. Are you receiving provisional pension?
Well, I am getting a fixed amount from 2007, 8840.
Paying him only fixed amount of provisional pension. Because 40 per month. We did not pay him the gratuity. You have not received this year's your DA. Why DA? Why you have said DA? You have not received DA. Last line of the chart. It should be DCRG.
It should be DCRG, madam. DCRG. Let's come retirement date. I'm sorry.
Ongoing and third. Ms. Boral and extending counsel for the agriculture department submitted. The criminal case against the petitioner is pending. Criminal case number 2. Being vigilance based case number 3/2005. Lodged on 27/09/2005 under section 420/468/471/120 read with section 13 small d small roman 2 13 of the Prevention of Corruption Act is pending against the petitioner. As such, he hasn't been paid the regular pension and other pensionary benefits. The As per the Assam Service within bracket Pension Rules 1969. Statutory rule under Article 309 of the Constitution of India as provided in Rule 21. Pertaining to withholding of pension or any part of it is exercisable in case of causing pecuniary loss to the government where at clause C 21 within bracket small b that was it. No, within bracket 21 CLA where no such judicial proceeding where judicial proceeding if not instituted while the officer was in service, whether before his retirement or during his re-employment, in respect of a cause of action that arose or an event which takes place more than 4 years before such institution, as per the explanation specified in Rule 21, it's clear. A departmental proceeding shall be a judicial proceeding shall be deemed to be instituted as in the case of a criminal proceeding on the date on which the complaint or report of police officer on which the magistrate takes cognizance is made. In the case in hand, the petitioner retired from service on 31/01/2004. The affair was lodged. Affair of state recovery. The case was lodged in such and such areas. On 27/09, affair of vigilance case number 3 of it was lodged on 27/09/2005. And search it in the case, said vigilance case, was filed by search it number 01 of the 2011, dated 03/01/2011. Apparently, any such cognizance taken against the petitioner by the magistrate will be after 3/01/2011. March. After 7 years of his retirement from service on 31/01/2004. On the next date fixed, on the prayer of list this matter on the prayer of Ms. Deborah, list this matter on 19th. The next date fixed. The respondents in the agriculture department shall advise the court pertaining to the status of payment of pensionary dues and other retirement benefits to him, like gratuity and debt come determining the condition. Being an employee, retired employee of agricultural department. This is
May I please your lordship? My senior is on legs, so please mark the matter for time being.
What's in it fix any other day, lordship?
No, your lordship, like my senior said, the matter has to be taken up today.
you are taking up now itself.
She is on legs. Can you please allow us to take
This
some
matter
time?
was earlier heard, lordship, on 15/5/2023, and our stand was particularly recorded, lordship.
Okay, let us see. We'll come and do the needful.
Lordship, will take up the matter after something or
After something, let us see. Let us hear the petition.
Lordship. The matter is regarding non-service salary as well as termination of from service. Lordship, petitioner along with other petitioners already have filed another petition, file number 2578 on 2015, seeking for a direction to release their salary. And during the pendency of this petition, inquiry has been conducted and found illegal, and some appointees are detected as doubtful. But both the present petitioners' name are not there. They are not doubtful nor illegal, detected as illegal. An affidavit has to be filed by the opposing party, but still that no affidavit has been filed.
Lordship, here the entire record is with the CM Vigilance, Lordship. Lordship, I paying for further 4 weeks time, Lordship.
What is the date of your appointment?
Petitioner number 1 appointed on 12/2/2000, and petitioner number 2 was appointed on 12/1/2005.
12/1/2005.
2005, petitioner number 2 was appointed, and petitioner number 1 was appointed on 12/2/2000.
What is your prayer here? What is your prayer?
My humble prayer, Lordship, kindly state a impugn order dated 24/5/2017, as because the Lordship kindly see the inquiry report. Inquiry as in inquiry report, my name, the petitioner's name was not nor listed as doubtful nor illegal. And in the on 34/2014, Deputy Superintendent of Police Laws and Affairs on CM Vigilance. My name is also not there, Lordship.
So you're not a doubtful appointee.
Not doubtful nor illegal appointee, as per reports, Lordship.
Where is the report that you are not your service not illegal? Tell us.
The inquiry report on next 4, kindly
What is against you? In that list.
only
your-
removal
your-
letter is against me, only removal letter. That is annex of 5.
Where you have stated that you have been appointed after following due process of Article 14 and 16. Have you annexed your appointment, your advertisement order?
No, Lordship.
When the selection was held, was there any advertisement before your appointment? Was there any advertisement before your appointment? Or you just applied and you got it? You have filed an
Just
application?
applied, no advertisement was there.
No advertisement was received. Is it a public post?
Lordship.
Was there any selection? Was there any selection?
I have to take instruction. Lordship.
It's a matter of 2017. What's the question of asking you for any instruction? Now
But the inquiry, as per inquiry report and
we are not on that. You have to establish your case. You are asking for some direction, right? So we want to know from you. What was your mode of appointment? You are receiving salary from public exchequer. So it's a public, even it is a grade 4 post. It has to be public employment. Now, in the public employment, as you have seen, without following the due procedure of Article 14 and 16, it cannot be considered. First of all, your appointment order, petition number 1, appointment order was issued on a second Saturday. Have you ever noticed that fact? 12th of February 2000 was the second Saturday. Anyway, if you have not been appointed by following the process of Article 14 and 16, what right you will have? First of all, you must have your right on the basis of some kind of appointment. Where is your right? Tell us. See, in this way, you can make thousands and crores of type copy, photocopy of your appointment orders. Or you can also have your signatures. Right? But if your appointment was not by following any due process of law, where will be your right? Mr. Saliha. Tell us in which particular police case, vigilance PS case, these records have been recovered. What is the reason for your appointment? What is the ground order? Kindly read at page 39. You are also what is the ground of removing you from service? Kindly read at page 39. Kindly read the first paragraph of 39. Page 39.
In persons of the order number so and so, dated so and so, which has been received today on 21/5/2017 from Director of Health Service, Assam, Hengarabari, Guwahati 36. The following persons are hereby removed from service as their necessary copies of documents could not be found in respect of genuineness of their appointment.
Anything else you'd like to submit?
Where our difficulty is the inquiry report.
Yes, you can understand your difficulties. You will never file your affidavit. Mr. Saliha. Taking the plea of some particular case, you always do that. $15 for necessary audit.
Yes.
Over 63.
We
have it on 8 because in better I've been told that Ms. Sharma is not available.
Yes,
today.
she is absent.
List on 8,
Your Honor, can I pray for stay, Your Honor?
not at this stage. Let it come on 8. We'll pass the order.
Oblige. Your Honor.
Inform Ms. Sharma.
Yes.
Inform Ms. Sharma.
Sure, Your Honor.
My lord, that is the lord. Lordship, it's the same issue, lordship, was before going on before the division bench, lordship, which is fixed on lordship 8-9, lordship, at the final disposal stage, lordship.
What is the veritable number?
The WPC number 2763 of 2019, lordship.
2763
of 2019. Lordship referred the matter before the division.
Along with those repetition or after the decision? Similar,
Not
you check.
Yes, madam.
Similar disorder.
That is the before NP. That is no NP with
Okay. Similar cost. The ASM November.
Oblal.
Heard Mr. Amit Rajbavi, counsel appearing for the petition, and Mr. B. Devi, government advocate Assam.
And for resolution number
3. Also heard Mr. N. J. Katania, pending counsel, Department of School Secondary Education for the respondent number 1, 2, 4, 1, 2, and 4. Matter pertains to non-governmental pensionary benefit and other retirement dues payable to the petition was the headmistress of B.K. Duar Bond High School in the district of Kachar, retired from service on 31/03/2017 on attaining the age of superannuation. During the deliberation of the matter, Mr. B. Devi appearing on behalf of the Directorate of Pension, placed a copy of the pension pay order number ADP, copy of the communication of the Directorate of Pension dated 25/07/2023 under number PIN, pensional PIN, P capital, dot ADP, all capital, oblique PPO, oblique GPO, oblique 2021-22, oblique 087864, informing the Treasury Officer, New Sales Treasury, forwarding the pension pay order number ADP oblique PPO oblique GPO oblique 2023 oblique 087864 in favor of the petitioner for an amount of rupees 39,570 as our pension with effect from 1/4/2017. With further amount of rupees 13,58,049 as date come return the duty as payable to the petitioner. Since the Directorate of Pension have already issued the pension pay order by 25, by its communication dated 25/07/2023. This petition has become copy of the communication of the Directorate of Pension dated 25/07/2023 placed before the court by Mr. B. Devi and the manager will be kept in the part of this. Petitioner has been paid a regular pension, but just the petition stands in this court. Yes.
May I please, Lordship? Matter relates to non-payment of salary.
Lordship, non-payment of arrear salary, Lordship, dates back to Lordship 22/7/2010 and to the month of January 2011, Lordship. And they have filed this petition in the year 2021, Lordship. So, Lordship, beyond 3 years, Lordship. So, Lordship.
My Lord, in between some developments are also there, which I have stated in my writ petition. I have submitted the documents which were sought by the respondent number 4 thrice, my Lord, which I have mentioned in my para number.
Have you approved the read court earlier?
No, my Lord. My Lord, in para 5, para 6, my Lord.
Whatever means the reason, have you, if you had approached the court earlier for any such type of direction, would have considered. But if you're asking for your arrear salary, the division bench judgment following in order of the Honorable Apex Court, it is very clear. Then you have to go for a suit or you have to file appropriate application for the authorities.
Here, my Lord,
Because if it is beyond 3 years period from the date of filing of the writ petition, the writ court will not be able to pass any such order in your favor. There's the law.
my Lord, but para 13.
Whatever.
Last, I have submitted on 1/6/2017.
You can understand, but you should have approached the court immediately. The period is long back, 2011, July 2010 onwards.
Yes.
Right? And you have filed this petition on 5th of February 2021. Your period dates from 2010 to 2017, I believe.
2010 to 2011 January.
So respondents are bound to pay you, but such direction cannot be issued in a writ court. You have the appropriate measure. In a writ proceeding, it can be considered only for a period of 3 years prior to the date of filing of the writ petition. That's how the law is. There is a division bench judgment.
2008 it is.
Not only assessing, justice
2013 2 GLT.
Yes.
109.
My lord.
You look into it and tell us on Monday. We allow that much. Go to Mr. Commander, tell him Buddha judgments. Give him the citation of Buddha judgments.
Yes, sir.
And declare the concept for the petition.
2013 109.
Based on Buddha judgments. The division bench judgment about also 2013
2 GLP 109. Yeah, please, your lordship.
Yes, my lord, in this case, my lord, the petitioner is the wife, my lord, legally married wife of my lord, late Vikas Purokasto.
What happened? What is your prayer here?
My lord, my prayer is that I am entitled to get family pension, my lord.
Who is not paying you?
They are not paying, my lord.
Who are they?
My lord, they are, my lord, Air Force Authority.
Air Force Authority.
Air Force Authority, my lord.
Mr. Gupta, you are appearing for Air Force Authority.
Lordship.
Why Air Force Authority is not paying us?
Lordship, in our affidavit, we stated lordship.
What is the reason?
The reason is that lordship, her name is not there.
It doesn't matter. She is a legally married wife.
No, lordship.
Mr. Sen is submitting.
No, another person's name is there. Lordship. Another lady is there, and that son is there. Lordship.
So we have to go for DA test, right?
Lordship.
Or what?
Lordship.
Now tell us if there are two wives.
No, my lord.
You are
in my
stating-
knowledge, my lord, I have stated in my affidavit in opposition, my lord. I have said, my lord, there is no such person in the name of Mitu Purokasto. What they say, my lord, that it is recorded in the service book, my lord. My lord, it has been inadvertently, my lord, recorded. So, my lord, we filed representation.
See, during the lifetime of your husband,
my lord,
he has recommended in his service book the name of the nomination was made.
But
that
my
is
lord,
Mitu Purokasto.
my lord, that is.
Are you Mitu Purokasto?
No, my lord.
Then
I am not Mitu Purokasto, but I am legally married of, my lord, the.
to be proved somewhere.
My lord, this is the certificate, my lord, section 35 of the Evidence Act, your lordship.
Who has given that certificate?
My lord, your lordship kindly see, my lord, my affidavit in opposition.
Have you made that Mitu Purokasto party here?
Mitu Purokasto is there is no
Non-existent.
existence, my lord.
What is the document you are saying that you are?
My lord, there is no existence, my lord. My lord, I have stated in my affidavit in opposition, and there is a judgment, my lord, in this regard. That, my lord, if legally married, my lord, if there is a, my lord, valid certificate, my lord. My lord, I have given the annexure 3, page 23. My lord, this is the marriage certificate, my lord. Now, my lord, who is Mitu Purokasto and how his name came in the service record, my lord, we do not know, my lord. Never I have heard the name of Mitu Purokasto, my lord. My lord, this Mitu Purokasto, has she been allied, my lord, she would have come and claimed for maintain, my lord, this pension. She has never come forward, my lord. And as per section 108 of the Indian Evidence Act, my lord, a person whose whereabout is not there, my lord, for about 7 years, my lord, it can be presumed that he is dead.
When did
My
you
lord,
lose
he
the
has-
affair?
My lord,
When did you lose the affair? For that purpose, you have to. There has to be a report from the police, right?
my lord, the police, I have not FIR, but the prima facie, my lord, prima facie, your
Mr.
lordship,
Sen,
my
if
lord.
you are claiming that 7 years period, there has to be a finding from somewhere, right?
My lord, your lordship, she is not claiming, my lord. There is no existence of such person. In such a case, my lord, Supreme Court has said, my lord, that if there is any valid certificate which is recorded in the public document.
Lordship, in our affidavit, we have annexed all the documents, Lordship.
My lord, in that particular documents, my lord, there is no my signature. Your lordship kindly see the documents that they have furnished, my lord. Only the name of Mitu Purokasto, but my signature, my lord, is not there. In their affidavit, they have furnished some documents, my lord. Your lordship kindly see. In that particular documents, my lord, my signature is not there. So how could they say, my lord, that Mitu Purokasto is the wife, my lord?
when my lord, we received the letter from them, my lord, then we file our representation that it has been inadvertently, my lord, recorded. So please correct it and, my lord, give the pension, family pension towards us, my lord. I am a daughter. I am having a daughter, my lord, who is studying in class 10, my lord. My lord, she is otherwise also entitled to get pension because illegitimate child is also entitled as per law, my lord. Illegitimate child, my lord, either son or daughter. My lord, their rule says, my lord, up to the age of my lord 25 years, daughter will get pension, my lord. If she is not married, my lord, or 25 years, whichever is, my lord, earlier. So my case is, my lord, that that it is inadvertently recorded, my lord. My lord, I am the legally married wife. I have, my lord, annexed sufficient document, my lord. Annexure 3 to, my lord, annexure 4. This is, my lord, bank account, joint bank account, and, my lord, annexure 2 is the, my lord, certificate. Your lordship will find, my lord, Nikita Purokasto is my daughter. My lord, therefore, my lord, I am praying. My lord, I have categorically stated that had there is any existence of, my lord, Mithu Purokasto, certainly, my lord, widow issue would have claimed for family pension. And certainly, my lord, we would have heard at any point of time regarding Mithu Purokasto, my lord. We have never heard, my lord. My husband never told, my lord. Therefore, where from they got this information, my lord, we do not know, my lord. But the records that they have given, my lord, the long roll, my lord, in that records, my lord, documents, my signature is not there.
Mr.
Lordship.
That nomination form
Lordship.
will bear the signature of the husband of the petitioner.
Lordship.
Produce it.
In
At least a copy.
Beware, Lordship. Not only that document, Lordship.
No, we have seen because that nomination form will be.
Lordship.
But that nomination form is not there. It has been nominated in the record that is there.
Lordship, details of the family is there, page 17.
That we have seen.
Page 17,
mother, son, wife,
even
sister.
one son is also there, Lordship.
We have seen that.
And it was a declaration of 1988, Lordship. 13 May 1988, Lordship. During the lifetime of the dead petitioner.
In that record, will have the nomination form. That will have it. That will please state.
Lordship. 1988 documents, Lordship, is there.
We have not heard, my lord, at any point of time regarding Mithu Purokasto. That is the surprise, my lord, and shock. Now, my lord, I am having one child, my lord. How could you survive, my lord? Lordship, kindly consider our plight, my lord, our difficulties. My lord, your lordship, my lord, my point is that under section, my lord, 35, my lord, there are documents, my lord, public documents, where my name has been recorded as, my lord, wife of Vikas Purokasto. She was getting pension. He died, my lord, in the year 2014. Thereafter, we claimed, my lord, they wrote a letter to us. And
Mr. Vacation Council appearing for the petitioner. And Mr. K. Gogo standing, Planet CGC for the respondent members.
124 for 120.
123, 120. Mr. Bora, you are appearing for whom? For Mr. Sam for the respondent number 4. Petitioners claiming to be the widow and daughter of late Vikas Purokasto.
Your lordship, my lord, see, my lord, the judgment, my lord, of the apex court, my lord. There is a judgment in such a circumstances, my lord, the authority should hold an inquiry, my lord, to see the veracity and, my lord, the claim of the petitioner. If it is genuine, then she is entitled, my lord.
Was an former sergeant. In the Air Force. Said because procrastination expired (26/08, 2014).
26/8/14. Connection 5.
When did he retire?
Lord, he retired in the year 2012, my lord. He took
Where you
voluntary
mentioned?
retirement, my lord. And
Where you have mentioned?
my lord, that they have mentioned, my lord, they know, my lord. I have taken, my lord, voluntary, my husband taken voluntary retirement, my lord. Thereafter, he was getting pension, my lord, during his lifetime.
And retired from service. Discharged from service on 30/11/1988 and was receiving service pension. The petitioners are now seeking for the family pension on the date of said request. The respondents in the Ministry of Defense filing an affidavit clarified that said because broadcaster nominated on Mitu Purakaster as his wife were married on 01/04/1981 which having his mother one son, having his son having one son, Antu Purakaster, ANTW. Mother, Konak Prabha Purakaster, and sister, Manusi Purakaster, Mansi, MANSHL. As recorded by Sid Vikas Purakaster on 13/05/1988. And as such, the respondent authorities in the Defense Ministry informed the petitioner in that regard for which the family pension the date of said because Purakaster cannot be paid to the petitioners. Or the petitioners by placing the marriage certificate of petition number 1 and her husband, Vikas Pastor, issued on 23/11/2009, stating that they got married on 06/02/1995, issued by the There officer, Kamruk Metro, as well as the joint account passbook of the petition number 2 with her father, with her eldest father, Vikas Pastor. However, the petitioner hasn't placed any such succession certificate being the heir of said Vikas Pastor. On the next date fixed, the responding authorities in the Defense Department shall place copy of the nomination made by said Vikas Pastor during his lifetime at the time of submission of consent documents. Mr. Gugoi, when?
See, it will take time. It will come from the MOD lordship, so it will take time, lordship.
Shall we have it on fixed on 9th of October?
Lordship, lordship. I will do lordship. Otherwise, lordship, the paragraph 5 of
We
the
have seen-
affidavit is lordship, lordship.
Only for the perusal of
Lordship, lordship, lordship. I will do. Oblige,
by
lordship.
way of filing an additional.
My lord, they have not produced the marriage certificate, my lord, my lord, in the official record. That your lordship has considered.
After retirement, lordship, after taking the all
After, my
pensionary
lord,
benefit,
my lord,
lordship.
This Mithul Purokasta, he never came forward for claiming. my lord.
Oblige, lordship.
I am obliged. I am obliged, my lord.
Lordship, may kindly see the last order, Lordship, on 9/8/23.
Yes, Mr. Gugoi.
There was a direction to
My
the
lord,
PHC.
Yes, Mr. Gugoi.
My lord,
Both
it will-
Mr. Gugoi is in
I'll request some more time. What had happened in this case, my lord, that regulation was without the approval of finance department. And since, my lord, a regulation is a question, the parent question of regulation was is under cloud, my lord. So it doesn't fulfill, my lord, that section rule number 31 of pension rules. To eligible for pension, one has to get my lord, regular post. So that regulation is a question. So we are processing it, my lord. We need some more time to come back, my lord. Otherwise, my lord, the department had processed, but this but finance has objected and sought some clarification. Even though, my lord, if you assume that there is a case, but ultimately it will lead to his cancellation only. That regulation he will be deprived. My lord,
Whose fault?
it was not our fault, my lord. It was, well, this person was sent to Assam Sewerage Board on deputation, my lord. That Sewerage Board, my lord, without taking any kind of approval from the finance department, my lord, bestowed the benefit of regulation upon the petitioner, my
Will
lord.
that bar him from all, because is it his fault?
It is not his fault, but my lord,
Then,
so it has to come. And now, my lord,
then if it is not his fault, he rendered service with the assumption that it was done by the to what particular department to whom he has deputed, because it was the duty of that particular department.
Serious board, my lord. So I have to seek some time, my lord.
Otherwise, he is initially he was an employee of the government.
Yes.
When the post was shifted,
To serious board.
along with the post, he was shifted to Suresh board.
He was not
Yeah,
shifted
he
to
was
the, he was
promoted,
not
Lordship.
shifted to the post,
Yes,
my lord.
post, Lordship.
I don't think so, my lord, that he's shifted to the
Because
post.
Suresh board
Unless-
were constituted initially. There was no such employees.
Yes,
So
sir.
along with the post, certain persons were deputed to the Suresh board.
My lords.
So
So I'll request some more time, my lord. This matters are under consideration. What has happened? This is not a single petition, my lord. Other batch of petitions are also coming from them.
Lordship, this is 2021 here, Lordship case. And he retired in 2019. Even they have not filed any affidavit except the executive engineer respondent number 4, Lordship. 4.
tell us when. Because see, the petitioner has retired from service
2019.
on February 2019.
That's it. Repeatedly, they are also seeking time to file affidavit or instruction.
No, no, we had filed affidavit, my lord. Initially, we are supporting that claim.
Tell us.
I require 4 weeks, my lord.
No, give us a date, Mr. Govind. You tell us.
Suresh board from 9 months.
Because you can imagine from 19 to 2023 without any pensionary benefits.
And on the last date, Lordship has specifically directed the PHC department, specifically the respondent number 1, 2, and the chief engineer to respond to the court, Lordship, or to take appropriate action.
Give us a date. They're not asking time that way.
Beach one, take it, beach one. Let's wait, let it be clear. Let it come on 20th, Tuesday.
14, Lordship. It may be taken up for final disposal, Lordship, on that day. Otherwise,
This taken like you, this taken. And my lord, this storage board must come in, my lord. It must be, the storage board also needs to be enrolled, my lord. RM does. Or the ministry which controls the storage board, my lord. Somebody has to come.
Not made a party.
Not made a party, my lord.
So we'll dismiss it. Non-gender of necessary party.
Lordship,
See,
they were reverted in 2000.
Court will not able to come to your help since you have not made the party here. You retired from this particular board, right?
No, Lordship, in 2011, they were reverted to PHC. And after reversion, Lordship, all the employees has been regularized in 2011, 11-12 itself, except the petitioners and 2 other employees. Their case is also pending in this honorable court, Lordship. But
Do you deny the fact that he was not sent to Suresh board?
No, he was sent, my lord.
Sent,
And the
Lordship.
regulation was given by that board, my lord.
from 1990 to 2011, he was
So
in
it's
Suresh
that
board.
board is a necessary party.
And there, he was promoted to the post of pump
Madam
operator.
Devi, you have not made the Suresh
Yes,
board a
Lordship.
party.
Party not
So I
sent.
will leave it to you, only you know. It's up to you.
Let's say,
It's up to you. You have come to
that's why I
know.
will implement the.
We do not know.
I will implement the. Lordship.
It's up to you
Suresh
now.
board.
On the prayer of Mr. D. Gogo, Standing Council, PHC, sorry. Twenty-six now.
26. Obliged.
Obliged.
May I please, Your Lordship. My Lord, Lordship, may kindly see the last order, my Lord, as per this, following the direction of this honorable court, my Lord, I have filed in IA to include, my Lord, the Commissioner and Secretary to the Government of Assam Pension and Public Grievances Department. A party responding to the case, my Lord, as respondent number 6, my Lord.
605.
I number 2480. Respondent number 6, my Lord.
Pardon, Mr. J. Sharma, counsel appearing for the applicant. Mr. Bora, you are appearing for whom? You are appearing for whom?
Lordship, I am for the High Court. Lordship. On the last occasion, your Lordship was directed to place the updated a revised payslip, Lordship. We have communicated but not received yet, Lordship.
What's your good name?
NK Sharma, Lordship.
Mr. S.K. Medi, and reconciliation in Assam for opposite party number 2. Mr. N.K. Sharma.
Correspondent number 3 and 5, Lordship.
Standing counsel JHC. Number 3 and 5. Opposite party number 3. And Mr. B. Gogoi, standing counsel finance for the respondent number 4. The petitioner, the applicant hearing. Well, you connect to WPC number 5941 of the 2021. Claiming his final gratuity. The applicant retired as an ADA of MS City Mumbai. And the said WPC number 5941/2021 is presently pending for disposal. By this application, the applicant has paid for increment of the Commissioner Secretary Government of Assam Pension and Public Grievances Department as party respondent number 6. The connected WPC number 5941 of the 2021. Because the language councils for the opposite party has no objection. The court is observed the view that the Commissioner Secretary Government of Assam Pension and Public Grievances Department is a necessary party for proper adjudication of the connected WPC number 6. Accordingly, the prayer of application allowed. The Commissioner Secretary Government of Assam persons have been implemented as party responsibility. Accordingly, this application is allowed. The concerned section of the registry shall correctly constitute the connected application number such and such. Next, in view of the order passed today in connected ISC number 2480/2023, the Commissioner Secretary to the Government of Assam in the Pension and Grievances Department, Pension and Public Grievances Department, grievances silo application from society number 0, silo number as respondent number 6. Indicating procedure. Concern section of the registry. So other than the correcting the first. Mr. Bora Government Advocate Assam has entered the clearance on behalf of the daily consultants. Issue notice. Petitioners have served the regular external office. 4 weeks to list of the 4 weeks and
Right. I'll start.
Maybe. My prayer for B.Ed allowance, my lord. I, my lord, passed from my lord Guwahati University, my lord, page 22 is my B.Ed certificate, my lord, in 2000.
When did you submit it before the authority?
My lord, submit, my lord,
When did
21,
you
my
submit
lord,
it?
page
Where is the
70.
receipt copy?
On 19/10/2021.
On 19/10/2021.
Yes, my lord, page 72.
Yes. You are deputed for the B.Ed training?
My lord,
it's a day course.
my lord,
Whether you are deputed or you are on leave,
my lord, date instruction I have not, my lord. With me.
then why?
My lord,
If you are a teacher serving in the school, how will you be able to do it from the Guwahati University without attending the classes? There is no such B.Ed course since 1998 or 2000. Prior to that, I believe.
in 2000, my lord, I serving to my lord. She had deficit junior college, Bejaraman.
Mr. Chauhan, kindly tell us from which B.Ed college you have done your B.Ed. You have passed your obtained your degree from Guwahati University.
Right.
But from which particular B.Ed college? You are very silent in your petition.
Of course, my lord, regarding deputation, I have not stated
Okay.
them.
From which B.Ed college you have obtained your B.Ed degree? You are intelligent, we know. The petitioner is equally intelligent. She is silent from which particular B.Ed college she has obtained her B.Ed degree? Will you able to tell us?
It is not in the certificate also, ma'am.
We know from where you have passed. But you have to tell us because you are silent. You will tell us on 8.
Lordship is there in annexure 4, your lordship.
Annexure 4.
Lordship, annexure
Page-
4. Page 22, your lordship.
Oh, it's in the certificate itself.
By Hata Shariali B.Ed College.
Oh, I didn't see it. But there is no mention in the writ petition. I was looking at a copy of this, the statements made in the writ petition.
Lordship.
Yes.
Click. Heard Mr. Swan as for the petition. And MS Sudi Musari Lanet and the Council Department of School Secondary for respondent number 1, 3, 4, 4. As well as Mr. B. Gugoi, Standing Council Finance for the respondent number 2. Petitioner is claiming advance increment, being a B.Ed degree holder from Guwahati University. The service of the petitioner was provincialized as lecturer in Bezara Ansolik Junior College. With effect from
The page 19, my lord.
page 19 is the not provincialization order, I think. This is brought under, okay.
Serial number
From
4 bottom.
1803-2014. Under the Assam Junior College within bracket provincialization bracket close Act 2012. Not 18, brought under channel. The petition since 1609, 1989, serving as a lecturer in the Bezara Ansolik Junior College. Said junior college was brought under deficit system of grants in aid on 17/02/2001 by an order dated 18/03/2014. Bezara Ansolik Junior College was brought under provincialization under the provisions of the Assam Junior College within bracket provincialization bracket close Act 2012. The petitioner is praying for a direction the respondent authority in the secondary education to provide her advance increment, being a B.Ed degree holder from Guwahati University. From the certificate of B.Ed degree issued by the Guwahati University to the petitioner on 04/01/2006. And next to this petition, the next 4, it is seen that the petitioner has done her B.Ed course by Hata Sariali B.Ed College by Hata Sariali District, Kamrup. The petitioner by filing an affidavit, additional affidavit shall place before the court as to when the NCTE granted its approval for opening of B.Ed course said by Hata Sariali B.Ed College by Hata Sariali District. Place this matter for admission only after filing such additional affidavit by the
Right.
In item number 21, handloom has filed their affidavit, my lord, and the petitioner also has filed the reply regarding finance. Finance
filed it.
Because finance also has to give a affidavit, my lord.
They have given my lord.
It's a file.
Actually, pleadings completed, my lord, in this matter.
Then, my lord, this is to be then fixed for hearing.
Because this is, my lord, we are claiming division of pay, my lord. 2010 we have been granted, but 2017 we have not been granted, my lord.
What is the stand of the finance?
They, my lord, their stand is that, my lord, first is that we are delisted from the public enterprises, and second stand is that my lord,
The matter was referred to the pay anomaly committee.
yes, no. They say that, my lord, I just, my lord, the audit report has not been submitted, my lord. Because of that, they could not consider. That is the stand of the finance department.
But otherwise, you are entitled for.
Otherwise, they say, my lord, we have not considered, my lord. We will consider.
Mr. Gogoi, if it is in 2010, you have given the benefit of ROP. Why not of the 2017?
Well, the issue is that they will have to adopt it, but they have to show that by resolution they have adopted.
By the 2000 ROP they have adopted.
So that's why, my lord, it might be in 2010, my lord, they have adopted. For 17, my lord, with approval they will have to adopt. Because otherwise they will have to pay it from their own resources.
Now, it has to come from the handloom and textile department or from the.
My lord, from the board through the, my lord, handloom and textile department.
Yes, Mr. Munir, whether any such decision was taken by the board? Whether any such decision was taken by the board regarding the application of 2017 ROP with regard to the employees of the Kadima? What Mr. Gogoi is submitting, that for the application of the 2017 revision of pay rules with regard to the employees of this Kadima, Kadian Village Industrial, it is a must that board has to take a decision for implication of the revision of pay rules. They were receiving, the employees of the Khadi board, they are receiving their such benefit of the ROP as per 2010. But they haven't received such benefit under 2017. The finance department's stand is that as there was no such resolution adopted by the board pertaining to the application of 2017 ROP.
In fact, my lord, the lordship may see your affidavit. Lordship may have a look at the affidavit filed by finance department. It was filed recently, my lord. Page 115. It starts from 115. Para 5, lordship may kindly see page 117. It says, my lord, the Assam Khadi and Village Industries Board receives granting aid from the state government, from where the salaries of the employees are paid. As per Khadi Board section 18(1), the board shall have its own fund, and all receipts of board shall be credited thereto, and all payments of board shall be made therefrom. So only the granting aid is paid, my lord. Now in next page, my lord, para 7, page 118, paragraph 7, the opponent makes to state that the handloom textile and agriculture department, white letter dated 6/1/2003, had allowed revision of pay to the employees of Assam Khadi and Village Industries Board as per ROP of 1998, with the condition amongst others that the Khadi board shall bear the entire financial liability arising out of revision of pay, and no additional funds shall be provided by the government. So whatever granting aid is paid, my lord, or in sanction or allotted, from there, my lord, they will have to manage. Again, in 2011, after publication of ROP 2010, Handloom, Textile and Agriculture Department had moved a cabinet memorandum for grant of revised pay to the employees of the board as per ROP 2010. Finance PRU Department had conveyed no objection, subject to condition that no post should be created in the board without prior approval of Finance Department, and the Assam Khadi and Village Industries Board Act would be amended accordingly. Cabinet has approved revised pay to the employees of Assam Khadi and Village Industries Board as per ROP 2010. In para 9, my lord, which will be relevant here, the opponent makes to state that as per recommendation of the 7.
Now, page 121, from which date?
As per notification dated 17/1/2018, the SL
From which date? From that
made the revision of pay as per ROP.
How did they say, my lord, 2006, 7 to
adequate
till
financial. Well, it is very clear. It says, well, if they have adequate financial resources to meet the additional expenditure arising out of the pay revision, so the burden will be upon them, my lord. However, later it was learned from Handloom and Textile Agriculture Department, Assam Khadi and Village Industries Board had been delisted from the public enterprises system.
This is delisted from 2002, my lord. Then also that 2010, they have been paid pay revision, my lord.
In page 123, the finances given is concurrence for giving revision of pay under the ROP 2017, subject to following up of these three conditions that we have mentioned. Condition 3 says the Assam Khadi and Village Industries Board will bear the entire financial liability arising out of their own budget, and no financial assistance will be given by the state government for this purpose. Disregarding ROP 2017.
Yes, Mr. Munir, what is your stand? As because you have been paid in 1998 and in 2010, it is automatic that will be also given in 2017. That is automatic. Or there are some requirements to be placed before the authorities. Is it automatic or something else is to be required? That you need to deposit something, you need to place certain documents. What are the documents that you have placed for consideration of the finance department to provide you this benefit?
While it takes up the affidavit reply filed by the.
Now just tell us, to get this benefit of ROP 2017, what are the things that was required by the finance department?
Yes, madam. Madam, currently if I come to this 150, madam, to the affidavit of reply. There, madam, the CEO of the board, madam, have written to the Handloom and Textile Department regarding supply of the all documents.
Kindly tell us what are the documents?
Yes. The query, with regard to the queries, madam, it has been submitted, madam. The total state of the officers under the board as on 31/3/2022 is 202 numbers. That has been furnished, madam. And with regard to the monthly requirement of funds, that is also provided. The liability to be increased as per ROP 2017 for the year 2016 to MPR. That is also provided, madam. The balance sheet, madam, up to the year 2021 has been provided. and the financial status that is also provided.
When did you submit?
Final, on 29/3/2023.
At the time of the revision of payrolls, these were sought for.
These were sought for, my lord.
When did you submit at that point of time?
No, my lord, these were sought later, my lord, by.
Only when after filing of this writ petition, these were sought for. But when did you submit before the handloom and textile? While the RO 17 was in process.
But those were not sought for. At the initial.
Why? It's open.
It was
All departments have submitted.
on 26th of August 2022, my lord, that was sought for.
See, basically, after filing of this writ petition,
Yes.
before that, when the 2017 ROP was brought into force, right, there was a big process, as you know, for the requirement of giving such benefit. Being representing the board, you are supposed to submit all those details at that point of time itself.
There was an office memorandum, cabinet memorandum, my lord, and in the earlier litigations, my lord, and it was adopted in the resolution that 2017 should be applicable to the
Resolution for that purpose, what you have done. When did you approach the handloom textile department as well as the finance department? These are only after filing of the writ petition.
After 2017, my lord. I do not have the.
That is why you want to know, when did you, because see, normally when there is a process for revision of pay, it's notified. All are to be submitted. Thereafter, all the finance department, the committee verifies everything. After going to the records, either you will accept it or you will reject it.
Page 39 of the writ petition, my lord, that is the finals of the meeting, my lord.
Yes.
Here, my lord, comes to page 40. Yes, the handloom and textiles and agriculture examples. Show you the eligible one. Handloom and textiles and agriculture department will examples the proposal of setting up the vacant post. Secondly, submitting the HG proposal for different of the board employees to the directors of employees to the textile department. Handloom and textile department secretary will examine for the approval of the board. That was the resolution adopted in this meeting.
Mr. Roy.
Lordship will see but the one finance affidavit, para 3, page 123.
Yes.
Then 124, my lord. Lordship may say that from 123 last para, as such the matter was taken up with the finance budget department, and it was observed that as per AG, Assam report, the accounts of Assam Khadi and Village Industry Board was not duly audited by the competent authority since 12 years. That is with
Where you are reading? Paragraph?
Page 123, last para, my lord. Yes. As such, the matter was taken up with finance budget department, and it was observed that as per AG Assam report, the accounts of the Assam Khadi and Village Industries Board was not duly audited by the competent authority since 12 years with effect from 2006-2007 onwards. As such, the present financial condition of the Assam Khadi and Village Industries Board is not known, and how the board will be able to pay the revised pay scale as per AS ROP rules 2017 for their officers and staff from the own source. Accordingly, the Handloom, Textiles and Sericulture Department was advised to get the accounts of Assam Khadi and Village Industries Board examined by the competent authority on the urgent basis, and after that the authority may decide for granting of revised pay. So they have not rejected it. They said that they cannot assess the situation because non-availability of the audit report, my lord. It has been learned that handloom and textile agriculture department that up-to-date audit has not been conducted as yet by the competent authority. Now I've been told, my lord, that 2001 to has been submitted.
Mr. Munir and Mr. Dharo, why the Khadi board was not audited for so many years? Why?
These balance sheets were not, accounts were not submitted to the.
Why it was not audited? We want to know from both of you. Why?
My lord, that is the board's thing there.
True, that is the reason. We are asking, that's the reason both Mr. Munir and you. Why it was not audited? If you have not been audited for the 12 years, there has to be some reason
That is
behind
what
that.
we raised, my lord, that you have to audit first, then come to us.
Balance sheets have been submitted to the auditor general, madam.
When, for which year and when?
From 67 onwards, madam, those are. 67 onwards.
Page 67.
67 onwards, madam. As well, the other balance sheets were not provided to the auditor general, whether the audit could not be done, and for that reason, my lord, the environment lecturer had asked the.
In 2022, you have done your audit for 2014 to 15.
My lord.
Very good. How will you give the benefit to the employees of the Khadi board? So blame is fully on you. The board has to take the responsibility. What was the hindrance of giving you the audit report? Why you have given the audit report of 2020, 2014, 15, 15, 16, all these years, only in 2022? Why? What stopped you from doing audit? So 2006 to 2013, 14, 2006, 7 and 13, 14, you have not audited.
All the balance sheet up to 2022, my lord, have been sent.
When?
Their affidavit para 13, my lord. Handloom affidavit. Page, my lord, it's 105. 105.
So that's how they will lose the benefit of the ROP. It's your fault. You have to pay it. The board have to pay them now, not the authorities. So you are giving everything in piecemeal. That's not good. They are not giving us in full. We don't know. Mr. Munir, that's not the way. That will not help us to pass any order. You want to give the benefit of ROP of 2017 by submitting the 2014-15 audit in the year 2022, 5 years after the coming into the force of the ROP. 2017 ROP came into force 1st of April 2016. So then will that help anyone? Will that help anyone? That order is very easy, even for the PS to write.
Now I am not in a position to extend the details because of the device, because now submitted.
Yes, Mr. Gogoi, Mr. Roy, tell us.
It will be taken on 14 by the time.
Time to giving time is very easy.
I know.
What will happen? Now assuming they will give now, let us assume.
But that part we have already mentioned in that particular para that it will have to be borne by them. They can go ahead, but it's very clear. Three conditions, the third condition is
But
very clear.
that
So far as
2010
2017 is concerned. So whatever granting aid is there, it is there. They may take a resolution, they may adopt it.
But it was a resolution allowed the chief minister of the state. The
Yes.
minus was the chief minister.
Yes.
Then
No, then what might be in the granting aid, some amount will be.
no, because coming of the giving effect of the ROP 2007 to the employees of the category. That's
Then
what
it
the
will be
minus
from
was.
April 2016, otherwise.
That's what the resolution was.
Yes.
That have been shown
Yes.
as a part of the annexes and the
Yes.
repetition.
Yes, madam.
If the chief minister signs a resolution, then what else?
Page 33, madam.
The third, if the minute is signed by the chief minister of the state, then
No, thank you.
it is there very much there. To give the benefit of ROP 2017. And that's why Khadi board was sleeping.
Yes,
Then we were able to escape that.
2018.
So this is after trade discussion. If you read the entire this minus,
No,
you'll
yes.
see
The Honeymoon Textiles will examine the proposal filling up the vacancy.
Page 39, madam.
you have seen that.
No, 40. Proposal for retirement. Retirement benefit is there otherwise.
Even the second clause that's giving the benefit
Yes.
of 2017. Third clause is the retirement benefit.
These are all suggestions. My lord, you may see the
We
last.
have seen, but there was a discussion.
Discussion is there, my lord. Finally, my lord, the finances not exist.
Difficulties are like that. The hopes will definitely be in the high and the other side.
Yes, of course. Expectation.
Item 22 is unconnected. I have confirmed with my lawyer.
We'll detach it. Don't worry. We pass order. Twenty-eighth of September.
But 28, my lord.
20.
Or 20.
20. It's a next day.
Item number 6.
Inform Munir about that.
Below the petitioners are the contract laborers of the ONGC. They are actually performing the perennial jobs of ONGC in the well field. Not actually well field, they are the supply helper to the regular employees who are engaged in the well fields. Now in ONGC, the contract laborers are enjoying some privileges. The contractor will change from time to time, but the contract labor will remain same. That apart, provident fund benefits are to be disbursed by the ONGC authorities, and similar other facilities are there. Now, my lord, if your lordship comes straightway, come to the page 35, where the contract laborers can be engaged. As types of contracts, your lordship will find that is the fair wage policy will be implemented in the following types of contracts. The contract laborers are guided by a policy that is called as fair wage policy. That is not very pertinent so far my case is concerned. My lord, it is one, job contracts for housekeeping, etc., etc. Contract for providing security, patrolling, surveillance services. Contract for running and maintenance of guest house and transit accommodation. Job service contracts for providing various services of office field, location, etc., etc. Now, so for the petitioners are concerned, they are not performing these types of jobs. In fact, they are performing the perennial jobs. And in such context, they should be considered as a temporary employee under the standing order in force. So at this stage, my prayer will be that a rule may can be issued to examine the aspects, and I have detailed everything in my writ petition, what types of jobs they are performing in detail. So they are to file an affidavit to controvert these things, and if they admit all these things, then probably these people can be declared as a temporary employee to be guided by the certified standing order.
You are appearing, Mr. Das?
Yeah, for the union of Your Lordship, for the ONGC also notice has to go, Your Lordship.
Yes.
There is a
Notice has to
panel of
go.
councils are there, but no standing councils.
Standing council is not there because I inquired about it. They are to file an affidavit. Either without filing an affidavit of this case cannot be discussed.
Council for the petitions. CGC.
For S1 number 3, Your Lordship.
Okay, I will.
It is contended by the petitioners that they are the contract laborers. Serving in testing section of well services as well as well stimulation service section. The claim of the petitioners herein that the respondent ONGC should consider them, should declare them
as a temporary employee,
as their own employees. Their services should be regulated by the employee standing order in force instead of
fair wage policy, page 35.
fair wage policy adopted by the ONGC on 18/07/2012. Issue notice returnable by 8 weeks. As such and such, no formal notice. Petitioner shall serve requisite such and such by 07 already. Petitioner shall take steps for service of notice on the respondent numbers 1, 2, 4, and 5. Registered for suit 80 by 07 such and such.
Right.
Mr. Court.
This endeavor is still on legs, sir, but senior is waiting probably, so I may submit. One of the petitioners. One of the petitioners were appointed as graduate engineer trainees in Oil India. In prior to 14/10/1981, you know. My lord, after that, on 14/10/1981, Oil India was nationalized by the Acquisition Act.
What is your prayer here?
Your Honor, for pension.
Are you entitled for pension?
Yes, Your
On
Honor.
what basis?
Your Honor, because we were appointed prior to 14/10/1981, and as per the Acquisition Act, all employees who were employed prior to 1981 would become members of the new. Become employees of the government, and members who were already present in the Burma of the pension fund, which already existed, would automatically become members of the new pension fund.
What is the stand of the Oil India?
They have stated that we have been employed as trainees, so we will not be entitled.
What is have you filed any objection with regard to that?
We have filed an affidavit
To be
in reply.
entitled for the pensionary benefits on the date of when the Oil India Limited was nationalized.
Yes, Your Honor. Yes, sir.
Right?
Yes.
What was the definition of an employee? To become a regular employee or such trainee employee or what? A provisionary to get the benefit of such pensionary benefits.
My lord, if I may request your lordship to put the affidavit in reply that we have filed, the Acquisition Act has been annexed. It should be in flag C, page number 17, Your Honor.
70?
17, my lord.
In your additional affidavit?
Affidavit in reply. It should be in flag C. In 3175, the file with the 3175/2017.
Your additional affidavit?
Affidavit in reply. I think like B.
Who signed it?
It has been signed by Ulfatul Rahman Bora. My lord, in page number 17, the act starts. My lord, may section 11 of the act. It talks about the transfer of service of existing employees and specified of the specified companies.
11.
Yes, my lord. It reads, my lord, every whole-time officer or other employee of a specified company who was immediately before the appointed date employed by that company in connection with its undertakings in India, or every whole-time officer or other employee of the specified company who was immediately before the appointed date temporarily holding any assignment outside India shall on the appointed day become an officer or other employee as the case may be. And it is an all-encompassing section here, my lord. It provides for whole-time officers and other employees.
You want to say that you come under other employees?
My lord, we have taken this submission on the ground that our provident funds were being deducted from our date of initial appointment as graduate engineer trainees.
Yes.
And my lord, as per the existing Burma Oil India Pension Fund rules, which was there prior to 1981, the requirement for becoming a member of the pension fund was to be, if from our salary slips, provident fund is being deducted, we become members of the pension fund. My lord, since our provident funds are being deducted from prior to 1981, our names should have been there in the pension list. In fact, my lord, there's a list of all pensionable employees that was procured by the petitioners in 1991. The names of the petitioners were reflected in that list. However, at some point of time, unknown, without any notice, without any reason given, we were removed from the list.
Yes, Mr. Kolita. If whether the petitioners will come under other employee or not in terms of this clause 11.
Though the petitioner has filed this petition, Lordship, but they have not annexed the appointment letter. We have, by way of our affidavit, Lordship, we have annexed the appointment letter. And
no, they will come under the category of other employees.
Lordship, they were appointed after the appointed date of 14/10/1981, Lordship. And therefore, Lordship, if Lordship please to our affidavit filed in WBC 5845 of 2017, Lordship, page 78, we have annexed some of the appointment letter. Page 78, clause 2.
What is the appointed day notified by the Union of India?
14/10/1981. That was the day on which the Acquisition Act came into force.
14/10/1991.
1981.
Whether the employee or other employees defined somewhere?
No, my lord. Employee or other employee is not defined, but those are the only two categories for persons who are in service. It's whole-time officers or other employees. And my lord may also peruse section 11 of the Acquisition Act.
We have seen that.
My lord, it says that in 12(1), where a provident, superannuation, welfare, or other fund has been established by a specified company for the benefit of persons employed by it or in connection with its undertakings, or for the benefit of such persons or persons employed by Oil India, the money is relatable to the employees whose services are transferred by or under this act to the central government or to a successor company, or as the case may be, continued with Oil India. And my lord, in section 12, subsection 3, it states the successor government company or Oil India, as the case may be, shall, as soon as it may be, after the appointed day, constitute in respect of the monies or other assets which are transferred to and vested in it under this section, or one or more trusts having similar objects as similar to the objects of the existing trust, as in the circumstances may be practicable. So, however, that the rights and interests of the beneficiaries of the trust referred to in subsection 1 are not in any way prejudiced or diminished. Apart from the pension fund, there was a provident fund and family pension fund. The petitioners are being the provident pension was a contributory fund which was deducted from the initial date of appointment as GT, which was being deducted, and then they were paid from the initial date of appointment. Similarly, my lord, family pension was also paid to the petitioners from the date of initial appointment. But for the purposes of pension, they have said that the initial date of appointment will not be counted.
Yes, Mr. Palita. Where you have stated. Mr. Chaudhary, you are referring.
Yes.
It appears the appointment orders of the petitioners have been annexed in the affidavit in opposition, it seems.
Yes, my lord. In affidavit in opposition in 5845 of 2017, their appointment letters are at page 66 onwards.
So whether these petitioners will come under the purview of these other employees or not?
In fact, if your lordship kindly goes through the last order passed on 15/5/2023, my lord, all my submissions have been recorded. In fact, my lord,
in the other petition, that is in 5845.
This should be 5845 in both the cases.
But it was in the headed by 5845.
Yes, my lord. That will save some time, my lord. May I read that order?
Yes, yes.
The case, I'm reading from paragraph 2. The case of the petitioners herein is that the petitioners, having been appointed as graduate engineer trainees, this is important, prior to 14/10/1981,
and as such, they would be employees within the meaning of clause 8B of the All India Pension Fund, for which they would be entitled to pension in terms of the All India Pension Fund. On the other hand, this encourages the Learned Senior Council by drawing the reference to the orders of appointment at graduate trainee, submitted that such appointments would not make the petitioner's employee within the meaning of clause 8B of All India Pension Fund. Referring to clause 2 of the order of appointment as a graduate engineer trainee in respect to one of the petitioners, which is perimetry in content to the appointment orders of the other petitioners, the Learned Senior Council submits that the first year of such appointment would be governed by the Apprentice Amendment Act 1973, while the second year will be governed by the contract with the Oil India Limited. It further submits that clause 4 of the said order of appointment would also show that pursuant to the completion of 18 months of training, a written test and interview will be held to assess the suitability for absorption in the company in the executive cadre. It was also made clear that if in clause 4, that there was no obligation on the part of the company to absorb on completion of the period of training. Further, referring to the orders of appointment of one of the petitioners as drilling engineer, production engineer, the same were made effective after 14/10/1981. And as such, the petitioners herein cannot be said to come within the ambit of the term employee mentioned in clause 8B of the All India Pension Fund. Further to that, the Learned Senior Council drawing the attention of the court to the rationalization of pay and perquisites of the executive of Oil India Limited, dated 1/11/1983, referred to clause 1.9 and more particularly clause 1.9.1, wherein it has been mentioned that the existing pension scheme shall, however, be restricted to only those executives on the rolls of the company as on 13th October 1981, and the executive who joined the service on or after 14th October 1981 will not be entitled to the benefit of the pension scheme. The Learned Senior Council further submitted that the petitioners at no point of time had challenged their orders of appointment in the executive cadre, as well as the document dated 1/11/1983, wherein it has been categorically mentioned that those appointments made after 14/10/1981 and such officers would not be entitled to the old pension scheme. So this is the case of the Oil India Limited. At the time, relevant point of time when these companies were acquired, they were apprentices. And after completion of training, they were appointed subsequent to that crucial date, and therefore they are not employees within the meaning of section 8B, clause 8B. As simple as that. Hmm? 14/10/1981 is the crucial date on which date the government of India acquired the entire shareholding of oil and Burma Oil Company under the Burma Oil Company and acquisition of shares of Oil India Limited and of undertakings in India of Assam Oil Company Limited and Burma Oil Company Limited, Act 1981.
But there is a division bench judgment recently you have seen where the advertisement relates back to, say, it was in that judgment it was of 1996. They were appointed in the year 2020, later, sometimes in 2021 or something like that. But considering the fact that their appointments basically relates back to 1996 advertisement, they should give the benefit of the old bench. That's a division bench.
There is nothing wrong in that.
Here, now the petitioners might have been appointed after the cutoff date, but whether their selection, because you said your recent
selection is also subsequent. That is what I am trying to point out.
Because that the appointment orders which you are placing,
yes,
that you are saying that in case of your selection to the recent advertising, recent selection, that's what you indicated. So whether the advertisement was after the cutoff date, their appointed day, or before the appointed?
My lord, at the time of the appointed day, they were apprentice and going for training. After completion of training, they may appear in the test, they may not appear in the test. Some of them have appeared and they have qualified and they have been appointed. So therefore, the question of advertisement of a retro date does not arise here.
They become apprentice without any selection.
No, apprentice was also a percentage selection, but that is only for the purpose of training. With that training, they get employment elsewhere in other oil companies. There are many, they have not.
So only for the purpose of training they were recruited, not for the purpose of absorption in his service in the oil India Limited.
Yes.
Yes.
My lord,
Show us
my lord,
whether that is correct or not.
my lord, means from
Your
page number 50.
initial appointment was issued for the training or only for the purpose of training.
My lord, we were issued salary slips. Apprentices are otherwise provided
Salary
stipends.
slip, when you are in training, you will be paid something.
My lord, we are paid stipends, my lord.
You have been paid stipends.
We have been paid salary. Otherwise, trainees are supposed to be paid stipends. My
So it's advertisement. Your
My
claim
lord,
has to be on the
my lord,
basis of the
may,
advertisement, how you are selected for the training.
My lord, may come to at the affidavit in reply that we have filed. It's in 3175, my lord.
That is the difficulty. We have to move around from one to other. Yes.
My lord, page number 38. This is one of the advertisements that the petitioners were able to trace out, my lord. In it, it reads, my lord, remuneration. If my lord is able to read remuneration, a consolidated stipend of rupees 700 per month will be paid during the
But
first
this is
year.
of which year?
This is of 19. This is prior to 1981, my lord.
No, this is, you see, basically advertisement of.
It's
has
reached,
to
my
be
lord. It should be reached by
sometimes of
February
1979,
My
because the last line says the application has to reach by 15th of February 1979.
My lord. So this was prior to all the petitioners were appointed prior to 1981, my lord. And these are the advertisements. My lord, it reads.
Just a minute.
My lord. I mean, affidavit in reply to the reply on file policy.
1911, 19 date. Document 9.
Acquisition of two officers.
7 to 18.
This is for additional affidavit of position from not piece of file policy.
এখন এখন নাই নেকি মানুহ থাকিব লাগিছিল
3175.
পজিশন নাকি এফিডেভিট রিপ্লাই কোটা আমার রেকর্ড নাই যে এডিশনাল এফিডেভিট এফিডেভিট ইন অপোজিশন
এখন কপি
we do not have that affidavit on record, my lord, on my record.
I'll provide a copy.
Because the affidavit in reply we have filed, we have received
Additional affidavit from reply.
additional affidavit. This is our additional affidavit. Affidavit in opposition. No, no, that is not with us. Yes, advertisement. Okay, we read it. pension. Photo pension. KTR date to this. Apprentice. Apprentice. Okay.
Yes, where is your salary part?
Hello, it says that we'll be paid all benefits as per
Let us see
company
where is your
rules.
salary.
Or the salary slips.
Have you annexed?
The salary slip, my lord, it's there, my lord.
Which page? Which repetition?
It's in the affidavit in
Which file?
41.
5845 or this?
It will be in 3175, my lord. Page number 41. These are the salary slips. In fact, my lord, the respondents have admitted that they have deducted provident fund in their affidavit in opposition.
41.
Yes, my lord. These are the salary slips.
Page number 41, 3175.
No, well, it's in the affidavit in reply. The annexure C or annexure B. Flag B, page number 41.
This is not your salary slip.
Provident fund slip, my lord.
Where is the salary slip?
I have one, my lord, this is not annexed. I have a copy of that. The salary slip of one Prasanta Palita.
Read the advertisement.
Applications are invited for fresh engineering graduate to be recruited as graduate engineer trainee in our drilling department. Applicants must have at least 60% overall aggregate marks in their qualifying engineering exam May I go to remuneration or?
Please read the entire.
Well, training schedule. Selected candidates will be for the first 12 months of training governed by the Apprentice Amendment Act 1973, subject to satisfactory performance. Training will be extended by another 6 months, after which, if they are found suitable and if appropriate vacancies occur, they may be absorbed as executive on probation. After completing 6 months as executive on probation satisfactorily, they will be confirmed as executive in grade B and the company. Trainees who shall not be absorbed as executive on probation will be released after 24 months. Remuneration. Consolidated stipend of rupees 700 per month will be paid during the first year and 750 per month during the second year. Pre-furnished hostel accommodation will be provided to all the trainees, and they will be entitled to free medical and other benefits as per company rules. The salary scale of grade B in the executive cadre of the company in rupees such and such. The salary inclusive of dearness allowance and additional DA at the minimum of pay scale will be at rupees 1175. Then applicants are supposed to send the documents.
Now, just see. Just, do you have a copy with you?
No, I don't have a copy.
Here, if you see, the basic was 700. So, to remain as an apprenticeship on that day, because you are given stipend, you're not given salary. This salary slip if you are wrapping up. So, if you are given stipend, and if you are in the first year of the training, you will come under the Apprenticeship Act. So, it doesn't give you any such benefit or any such to be included or inducted unless you first complete the second 6 months. The first 12 months, you are under the particular Apprenticeship Act. Then the second 6 months, the executive training. If there are posts, you will be absorbed if you successfully completed the first 6 months. Then you will be absorbed in the executive training for the next 6 months. If there are posts, these are very specific. So the next 6 months, first 6 months executive, then posts are there, you will be inducted there, not for the service, for the training. They have categorized that way. Till the completion of training, you will become an employee of the Oil India Limited or Burma Oil Company Limited at that point of time. During the training period, whether you will be considered as an employee or other employee.
For the purposes of the Apprenticeship Act, we may not be, my lord, but for the Acquisition Act, it's an inclusive definition.
How you remain as a trainee only?
But our services were transferred.
When you become an employee?
My lord,
tell us when you become an employee.
My lord, for the purpose.
Here, application was purely for the purpose of training.
My lord. But the provident funds were deducted. As per the rules of the provident fund, my lord.
As because the provident fund is deducted, will be a regular employee or other employee.
But my lord, the provident.
Who was the provision of employee?
My lord,
whether trainee will come under the employee or not.
My lord, it is. I understand, my lord, that that's a weak ground on my part, my lord.
That's why the Apprenticeship Act is very clear.
Very clear, my lord.
Right. That's why the Oil India Limited, while they giving this advertisement was clear. The first year, yes, still under the Apprenticeship Act. There are two other clauses for the next, because it was categorized for 24 months.
But my lord,
next 6 months, first 6 months, then second 6 months.
My lord,
you would have understood that had it been, because there is a particular clause, if the posts are available, the second 6 months, they are then be inducted, and if you successfully completed the second 6 months, then you will be absorbed. That will mean by what?
In practice, however, all the persons who were taken as graduate engineer trainees were appointed. But secondly, my lord, the advertisement, my lord,
appointed when?
They were appointed as executive cadres, which, as per the advertisement,
from the completion of the training or from the date of when you enter the training?
From the date of entering as trainees, my lord, for all purposes.
So was anything like
my lord? My lord, we come to the page number 52 of the writ petition, 3175. This is a type copy. Page number 53 will be more relevant. This is a list of pensionable executives that is maintained by the Oil India. This is from 1996. In the column it says name, grade, SPH, and joining date. My lord, may come to 9
Page
from
number 52 of 3135.
my lord, 3135, 3175.
52, 52.
52, my lord. Of the repetition. I apologize, my lord. There's no running page number. Well, 52, it's a list of pensionable executives that was maintained, and this is from 1996. In the 5th column, it mentions the joining date. And all the petitioners' names are there, and their joining dates are prior to the date of acquisition. That is the date from which Provident Fund was deducted, and then later upon superannuation paid. Family pension was deducted and paid. But for the purposes of pension, when we do not even know, we were given no notice when our names were deleted.
Mr. Chaudhary, after the completion of the training, this advertisement, as you have read, is very clear. The first 6 months executive training, then again the second part, the posts are created, then it will be available, then it will be there in the second part of the training. Now, after the completion of training, whether these trainees are straight away inducted without any appointment orders, or they are considered their appointment from the date of their initial training.
My lord, that is, your lordship will find at page 34.
34 of
in our additional affidavit.
Additional affidavit filed in which repetition?
3175. In fact, several I have annexed, my lord. One, firstly, my lord, page 32, we have given the, my lord, executive trainee scheme, then the appointment letter. Because this will be, they will be governed by this appointment letter. And this is under challenge. Just page 34, may I read, my lord?
Just let me get it. So many
affidavits. It's not that, my lord, after the training is over, they were straight away absorbed. There was an interview, there is a selection process. That is, my lord, manifest in the order of appointment. There, this is, my lord, regarding their appointment as graduate engineer trainee. Then I'll show your lordship the appointment as their production year. This is of May 1981. This is prior to the crucial date.
Page 44.
Page 34, man.
34.
34. Just to make one point clear, my lord, as if they are not getting any pension, they are enjoying pension under a different scheme. That I'll show, man. And the amount also I'll show. And the list that was shown, my lord, the pensionable, the executives, naturally their names will also be there because their service is also pensionable, but under a different scheme. Page 34, your lordship will find the appointment as graduate engineer trainee. Has your lordship got it?
Yes, yes.
May I read it? We are writing with reference to the interview held for recruiting graduate engineer trainees and are pleased to advise that you have been selected for training in our organization for a period of 2 years. The first year of your appointment will be governed by the Apprentice Act 1973, while the second year will be governed by a contract with the Oil India Limited. During the period of training, you will be paid a consolidated stipend of rupees 1,000 per month and for the first 12 months and rupees 1,050 for the remaining period, subject to your signing a bond of rupees 20,000 for serving the company for at least 3 years after completion of training. You are therefore requested to sign the enclosed bond and arrange to have it duly countersigned by a surety and submit it to us personally. Income tax on your stipend will be deducted. The continuation of your training after the first 12 months will depend on your performance during that period. Nearer completion of a total 18 months training, a written test and interview will be held to assess your suitability for absorption to the company's executive cadre. This is, however, without any obligation on your part to absorb you in our organization on completion of the period of training. Subject to your qualifying in the test referred to in paragraph 4 above, and subject to there being suitable vacancies, you will be considered for employment in the executive cadre of the company on probation for a period of 6 months. On satisfactory performance during the probationary period, you will be confirmed at the end of a total 24 months training. If you qualify in the test referred to under the paragraph 4 above, but cannot be absorbed due to lack of suitable vacancies, you will continue with your training for the remaining 6 months. If in the meantime vacancies arise, then you are offered employment, your probationary period will be adjusted. Now, my lord, these are the conditions under which they were given the training as graduate engineer trainees. Then, my lord, appointment letters came in June 23, 1982, that your worship will find in the affidavit in opposition.
Just a minute, just a minute. Yes, appointment orders.
Before that, your lordship, since your lordship is taking of this affidavit, last page, your lordship will kindly see page 69.
Yes.
This is, my lord, the pension payable by the respondent 1 to the petitioners. They are drawing this much of pension, 81,547, 67,000 all. And they are also drawing pension under OIB. So there are two schemes.
All India, you have a
contributory pension that has not been drawn.
So it's not that they're not getting pension. They want to get the benefit of the pension of the employees who were employed earlier to the acquisition. That is their case. Now your lordship will kindly see the appointment later. Page 69 of the affidavit in opposition in 5845. Appointment letter. Has your worship got it? The appointment letter. May I read it, ma'am?
Yes, please.
Appointment as production engineer. We are writing with reference to your recent interview and have pleasure in appointing you as production engineer. That indicates that there is a selection process. In executive grade B in the production department of the company on the following terms and conditions. The appointment is effective from June 30, 1982. They are governed by these appointment letters, and these appointment letters are never under challenge. From which date you will receive a basic salary of 805 per month, dearness allowance at rupees such and such per month, and additional dearness allowance. These allowances may be amended. Income tax payable will be deducted. You will be required to serve a probationary period of 6 months. Then, on satisfactory completion of the probationary period, you will be confirmed. So this is there, my lord. Order.
So there are two parts you have to say. The first part is the training period.
Yes.
Previously, and thereafter the probationary period. Because after this appointment, they will be on probation, and they will be receiving the scale pay.
Yes.
Prior to days to receive the stipend,
Exactly.
along with some special pay, whatever it will.
My lord, from what I've understood, the process in which it was contemplated, this entire service was contemplated, is that my lord, they'll be appointed as apprentice. There is no denying it, my lord. They were appointed as apprentice. But the scheme of how it was supposed to be was that once they are appointed as in the executive cadre, their services will be considered from the date of appointment, my lord. And pension will be accrued, all superannuation benefits will accrue from the date of appointment. My lord, if I may again ask, request you, my lord, to go to another page, my lord. It's in flag D, my lord. There's a Burma.
Before you may complete, my lord, I want to refer to one more document only, my lord. In that affidavit, your lordship may kindly come to page 102. Because the stand of the, my lord, the Oil India is clear in this regarding their pension. 102, subject rationalization of fee and perquisites to the executive of Oil India Limited. This is dated November 1, 1983. Your lordship may skip other things. Your lordship may come to page 105. Last paragraph, clause 1.9. Retirement benefits. There is no change in the provident fund and gratuity benefits. The existing pension scheme shall, however, be restricted to only those executives on the rolls of the company as on October 13, 1981. The executives who have joined service on or after October 14, 1981 will not be entitled to the benefits of the pension scheme. But my lord, in the affidavit, we have also stated they are entitled to the pension under the All India Employees Pension Fund and Oil India Superannuation Benefit Fund. So from that they are entitled. So this is the crucial date, and your lordship is seeing the date of appointment.
Okay. Anything leaving aside this, so they are getting two components. One is Oil India's employees superannuation benefit scheme or something like that.
Yes, and All India Employees Pension Fund.
So together they are getting that one. Both, they will come under both the schemes.
Yes.
But will not come under the pension scheme.
Yes. Oil India Pension Scheme, Pension Fund, under that they will not come.
Yes, you wanted to show Mr. Goswami.
My lord, let me first state this, my lord. All the employees are of Oil India are entitled to two schemes. Gratuity, they'll get a contributory pension fund from there. There is a Oil India pension fund which they have stated, which is not a contributory fund for persons who have been appointed prior to the date of acquisition. And there is a contributory pension fund which is for employees who have been appointed subsequently. They have stated that we are entitled to the subsequent pension fund. This is why we have approached the court. I don't know, come to the affidavit in reply, we have filed to the additional affidavit since flag B. Page number 7, we have applied, we had filed an RTI as well, my lord. We could not, they had refused. So we found this in extract, my lord. This is the Burma Oil pension rule existed prior to nationalization. It states, my lord, the following employees shall be members of the fund. Persons who entered into a specified category of service with the company as detailed hereinafter 1st January 1973 and who are members of the Burma Oil India Provident Fund and Provident and Insurance Fund India. We have been, from our stipend fee or salary slip, our Provident Fund has been deducted and it is not even denied. From this, which I draw is, my lord, for the purposes of joining the service, we joined as apprentice. But as if this rule is looked into, our pensionary benefits start from the date of our initial appointment as graduate engineer training. In fact, my lord, even for promotion and other service benefits, our date of initial appointment is considered. And my lord, our names are there in the pension list. That is not, and in that list, our date of appointment is mentioned as prior to nationalization. This is why we have not challenged the rationalization of pay letter that my senior has just now produced, my lord. Our names are there. As far as we are aware, my lord, this is the executive cadre role. And in the executive cadre role, our names appear.
The definition of an employee or a trainee.
Employee, my lord. My lord, it is not.
Definitely has to be, there will be something somewhere.
The definition of member beneficiary is there, madam. To the pension fund, who will be a beneficiary and will be a member to the new Oil India pension fund.
Who's an employee normally?
The person who is a master servant relation with a company. Hello.
Who's a trainee?
But they have been specifically said to be an apprentice, madam. But they have been promised.
No, because your entire argument was only one thing, that is, you will not come under the regular employee, you will come under other employee. How do you explain this other employee?
Because
this is why you have to must establish the first that you are an employee.
I would say that
employee will have a fixed pay or employee will have something else.
They might usually they have a great pay, my lord. That is not denied. My lord.
So necessarily, if there is an employee, he will have some kind of skill pay.
I understand.
So possibly there may be a fixed pay employee also. But thing is this, as per that particular advertisement, because here what Mr. Chaudhary has placed is the advertisements are after the cutoff, because it was in 81. It was not in September, maybe prior to that, maybe during the time. The thing is this, they are also earlier advertisement which you have annexed, it was 700 rupees, but which Mr. Chaudhary has placed it is 1,000. So subsequent advertisement, not of that 1979. If we go by that advertisement, this should be the petitioner, one of the petitioner, one of the things. Then in that case, you will see again same thing as that of the advertisement which you have annexed of 1979. So first of all, unless you clarify who is the other employee and you come under the other employee. So if you have certain documents, if you can place it from any documents in place, because you have accessed the affidavits.
If I may make one submission, my lord. The Acquisition Act was a complete act, my lord. It is for transferring all the assets of Burma Oil Company into the government of India. If it provides for whole-time officers and other employees, I would submit, my lord, that the clause will have to read as every person who has been considered to be under the employment.
So there is a special provision which by All India was giving training.
My lord, even those would be considered because this is under a special act for a special purpose to transfer everyone's service.
So the trainee will be an employee. That is what we are. If you can clarify anything from any judgment of the apex court.
In fact, my lord,
the trainee during this period will be considered as an employee.
For their appointment was definitely as a trainee, my lord. But as contemplated in the
your appointment was as trainee
in as per graduate engineer trainee, my lord. It was as a graduate engineer trainee, my lord. But
it was a conditional.
It was conditional, my lord. But the Burma Oil pension fund rules that existed, I would submit, my lord, it contemplated a fact where if their services are continued.
Now, Mr. Goswami, just tell us one more. After the appointed date, so those who were serving as a regular employee or other employee as on the appointed date, they will be entitled for that pension benefit.
My lord.
Right? There was a fund with the Burma Oil Company, and from them they will get that benefit. It was the pension.
Right.
Other employees who served or been appointed after the appointed date, whether they are getting pensions in terms of the amount that was specified by the Burma Oil Company.
I suppose, my lord, the probationers also were paid, my lord. Were on probation, have received pension.
Provision only after your appointment.
My lord.
When you are inducted in the Oil India Limited.
Now, these 12 petitioners are in a special class. These are the only persons who were appointed as graduate engineer trainees, but had not been inducted as executive engineers. These are the only 12 petitioners, my lord.
Special category.
Yes, my lord.
So how will you equate with the other categories?
I'm not trying to equate with the other categories.
Get that benefit.
But my lord, I'm stating that if the new fund that was created by Oil India, it categorically stated that the beneficiaries would be the existing rights of the beneficiaries of the old fund will be protected. Now the question comes, my lord, whether the petitioners were beneficiaries of the old fund. It is my submission, my lord, that since Provident Fund was being deducted, as per the old Burma Oil India Pension Fund rules, once Provident Fund is deducted, you become members of the pension fund. And since they are members of the pension fund, old pension fund, the new pension fund must consider them as beneficiaries.
So according to you, since your PF fund was deducted,
My lord,
so you'll come under that fund.
we are a member of that Provident Fund, pension fund, the old pension fund. And this is, my lord, not a provident fund as per the National Provident Fund, my lord. Oil India has a different provident fund that is created by its own rules. So this is the Provident Fund rules are of Oil India specifically.
How will you explain it? Yes, Oil India has deducted the provident fund amount from their salary or stipend, whatever.
Let me address the court from a different point of view. Their prayer in the repetition is that they should be given pension as per their entitlement. That is the prayer. So prayer in effect means that give us pension under the Oil India Pension Fund.
Right.
And what is the Oil India Pension Fund, your lordship has to see, because that is not under challenge. Oil India Pension Fund, your lordship will get in the repetition 3175 at page 22. Unless this is challenged to be bad, and unless they challenge their order of appointment, they cannot come under this fund. It starts at page 21, Trust and Rules, Oil India Pension Fund. Your lordship may read page 22, second paragraph. Whereas the company has been securing pension or pensionary benefits in respect of the employees of the company through Burma Oil India Pension Fund, hereinafter referred to as the existing fund, a fund established for the benefit of the employees of the Burma Oil Company Limited and of the employees of associated companies. Employees is the word. And whereas the existing fund is an approved superannuation fund within the meaning of section 26 of the Income Tax Act, then your lordship may skip and come to the page 29. The rules. Clause 1C. The fund shall be deemed to have come into operation on and from the 14th day of October 1981. Now, definition part. Clause 2, Rule 2, E, beneficiary. Beneficiary shall mean any individual presently or prospectively eligible for benefit payable under the rules and shall include a member as hereinafter defined. And the member has been defined as clause J and K. Former employee means a person who was a pension employee of the company and was a member of the fund as at the date of his retirement from the service of the company. So those who were there. And K, member shall mean an employee of the company who has been admitted as a member of the fund in accordance with the rules, but shall not include an employee who, having been admitted as a member, has subsequently retired. So, my lord, this is specifically for the persons who were appointed prior to the Act came into being. So moot question is from which state you are an employee of the Oil India Limited. The answer is very clear from the date of your appointment order. Appointment order is very clear. Only because, my lord, the earlier employees, existing employees get a little more. That is the only grievance they have, my lord. It's not that they are deprived of pension. And for that, the answer to your lordship's query about the provident fund, deduction of provident fund, well, for that I have to take your lordship to the, my lord, the scheme of the apprentice, because they have been appointed as apprentice under a scheme.
But it will be only for the first year.
Yes, my lord.
First 12 months.
First
during
12
their training.
months. Thereafter, next 6 months, that is already there, your lordship has seen. But thereafter, there is a process of selection. After selection only you get appointment, and you have been appointed subsequently. The executive trainee scheme your lordship will get in our additional affidavit at page 12. They cannot come out of the mandate of the scheme. Because their trainee as executive, that is subject to qualifying in the test and subject to availability of vacancies.
That's right.
Therefore, they were not employees at the relevant point of time.
Yes. You want to place which document?
In our, my lord, the All India Superannuation Benefit Scheme, that is at page. Well, I can just hand over a copy. This is the superannuation benefit scheme. We have stated that in paragraph 11 of the affidavit. Some are also drawing this benefit. All India Superannuation Benefit Scheme will apply to all executives of the company drawing pay in the regular scale of, I am reading 1.5, which includes executives who were on roll on 1/1/2007 and the new entrants joining after 1/1/7. The scheme will also be extended to the unionized employees of the company drawing pay in the regular scale of pay. However, the scheme is not applicable to the following: contract appointment, temporary appointees, executives on deputation from other organization to Oil India Limited, apprentices and apprentice executive trainees, and employees covered under Oil India Pension Fund. So, who are already? So they are getting benefit, but this, my lord, the other existing employees under the Oil India Pension Fund, they do not get this benefit. And they are drawing, some of them are drawing it. In paragraph 11 of our additional affidavit, we have stated that. And therefore, those petitioners could not have made a challenge or make a prayer, taking a benefit.
Not all the petitioners have not accepted the contributory pension schemes.
So let those petitioners be ousted who have taken the benefit.
But Nakara cases there, my lord, that it is not a bounty, my lord.
No, Nakara case is whether the pension is a bounty or not. And regarding the fixing of a cutoff date, that is DS Nakara. We are not giving as bounty. Under a scheme, you are getting the benefit. Two benefits, in fact. and you want to shift to other pension fund, which the scheme of the fund does not permit it. So, Mala, sum and substance is that on 14/10/1981, they were not in employment of the All India Limited, and therefore their scheme, pension scheme is different, and they are getting that benefit. They cannot get the benefit of the existing employees who were in appointment before the acquisition.
In the second part of your training, they remain as a contractual employee, or there is a contract between the All India and them? Because as per that order, there has to be a contract. Because first part is the apprenticeship at first 12 months, then second 6 and 6.
Second stage, since there are vacancies, a test was held, and they were appointed. Therefore, there was no contract service in between.
Now, if it is a contract service,
no, there was no contract of service. They were apprentice. They were continuing as trainee, and then there were vacancies. The selection process was held. They were found suitable, and they were appointed on regular basis.
In fact, most of the petitioners got appointed prior to completion of 2 years. They were not in the GET for.
You are a group of how many?
12 employees. In fact, the respondents have themselves considered us as employees, my lord. Have the entire pension rolls, which specifically state the date of joining. It is not that we have contemplated another date and the respondents have been stating it to be something
All
else.
India is a very profit-making company, you know that. The thing is whether you are entitled for
my lord.
That is what the issue is.
Yes, my lord.
If they would have wanted, they would have given to you also. If you are only 12, it hardly matters.
My lord.
Now, following that particular issue, anything else? But unless you show anything that you come under other employee.
Lord, I would submit my lord.
Only because that your PF amount was deducted. That's how you born into that category.
Our names are reflected, my lord, in the pensionable employees list. There are two lists that the petitioners were able to get their hands
Might
on.
have been prepared, but whether preparing a list doesn't
They
mean
are
that you are
pensionable.
entitled.
They are pensionable. They have got their pension.
Pensionable in the other two schemes, not under the All India Pension Fund.
1996, my lord. 1996, the new scheme did not come.
That's why you are asking for to get the benefit under the All India Pension Fund.
My lord.
But whether you come under that or not, that is a test of experience.
My submission is that the process how it was contemplated is, since there should not be any issue that we have been appointed as executive engineers, graduate engineer trainees, within 1 month we have left the service and they have invested so much and now they have left. Or we should not come and ask for a permanent job just because we are employed as executive engineer. So the scheme was contemplated in such a way that we were appointed as apprentice. But if our services are continuous in nature, then our date of joining for all purposes, all service conditions would be considered from the date of appointment as graduate engineer.
That he has to show from the scheme, my lord.
Because even
I'll
for
drop-
promotion, the petitioners are being considered from the date of appointment as GT. And we were never informed, my lord, because under the pension fund rules, my lord, there is a way in which if we were not a part of the pension fund, existing pension fund at the date of appointment, but we would have become, they are supposed to intimate us and we are supposed to communicate.
No, that was made clear in 1983 itself.
Well, from 81 till 83, our services have been continuous, my lord. And 83 is a notification which was passed explaining what the company is contemplating. But the act and rules remain. In fact, my lord, there was a VRS scheme which the petitioners were not allowed to take because they were appointed prior to 1981. Throughout their services, they have been considered to be employees appointed prior to 1981. But one by one, when the petitioners started retiring, they were denied pension.
No, that is a wrong statement. That is a wrong statement. In 1983 itself, it was made clear. And you have to see the scheme of the training scheme and the, my lord, provident funds, the employees provident fund, sorry, my lord, the employees pension fund scheme. They do not fall under it. Our hands are tied. We have to go by the, my lord, the rules. After completion of training, taking an appointment in 1981, accepting the terms and conditions, after retirement, you come and challenge it. Even you do not challenge the appointment letter as bad.
See, basically, the appointment order, in fact, for the training itself is very clear. Continuation of your training after the first 12 months will depend on your performance during that period. Nearer completion of total of 18 months training, a written test and interview will be held to assess your suitability for absorption into the company's executive cadre. This is, however, without any obligation on your part to absorb you on our part. It should is on our part to absorb you into our organization on completion of the period of training. So unless you are inducted or absorbed into the organization, to remain out of the organization as a trainee, then
my lord,
that is why we are asking you, how will you establish your case that you remain as an other employer?
Well, because there are only two categories of employees, my lord. Two categories of persons who have been transferred. It cannot be denied that our services were transferred, my lord. As per section 11, there are two categories, whole-time officers and other employees. We have to fall under one of those two categories if our services have been transferred.
It's not services, it's a trainees. The trainees are also transferred. No, my lord, I'll just conclude my submission. The petitioner cannot say that the executive trainee scheme is bad. That is not under challenge. The petitioner cannot say that employees pension fund is bad because that is not under challenge. The petitioner cannot say their appointment order is bad because that is not under challenge. Then what remains, my lord, in the rate petition? And some of them take the benefit of the other scheme. They are not similarly situated. They have joined hands in a petition where they are not similarly situated. Two of them doesn't have the locus to file this writ petition.
If I may submit, the section 11 of the Acquisition Act talks about transfer of service of existing employees. If, since our services were transferred, my lord, it can be seen that our services are also transferred as per section 11. And section 11 contemplates only two categories of persons. Either we are full-time officers or other employees, which is why it's a special act only for the purposes of transfer of the assets of or acquisition of the assets of Burma Oil Company by the government of India. In fact, my lord, this rejection our representation was rejected. It was rejected by the board, my lord. Whereas as per the pension fund rules, the decision is supposed to be taken by the trustees. And my lord, we have not challenged the rationalization of pay letter because our names appear in the 1996 list.
Which Mr. Chaudhary has pointed out that letter of offering of trading to you, one of the petitioner. There at para 11 was categorically observed. In fact, it was a specific direction. If the above terms and conditions are acceptable, we request you to sign and return the duplicate of this letter in token of your acceptance for the training. You are, however, advised to inform us immediately by telegram that if you will join us on or by June 22nd, 1980.
Hello. But that's why.
So, your appointment as graduate engineer trainee on joining will be subject to your being found medically fit. So it is very specific. You are joining as a trainee.
My lord,
so on that particular date, that particular appointed date, you are graduate engineer trainee.
My lord.
So show us that you will come under other employee category.
That is what I'm stating, my lord. If there was no acquisition, or let's contemplate.
There may be other employee you do not know.
Yes, my lord. If it was not, we were not acquired by the government, our services would have been, our services would have been considered from the date of joining, and our pension would be from the date of joining, my lord. Now, here is a situation in which, by an act, the government has acquired all the assets of Burma Oil Company, and it has been done through a specific act. And section 11 says that the transfer of services of employees, which means that if since our services have been transferred, it has to be governed by section 11 and 12.
Okay.
In fact, my lord may see that in the second writ petition, the respondents, Oil India, have rejected our claim. Our representation has been disposed of, but that representation has been disposed of by the board of directors. Whereas as per rule 4 of the Burma of the Oil India Pension Fund rules, the decision can only be taken by the trustees if there is any conflict. But in fact, there is a judgment, my lord, which was delivered by WPC my lord 4110 of 2016. It was disposed of in my lord on 24/3/2023. Otherwise, there are also Oil India. It's a case against Oil India. The only differences are, my lord, these persons were appointed temporarily before 1981, and then again subsequently they were after a gap they were employed. Whereas our services are is continuous, and our provident fund and my lord, I've already stated provident funds have been deducted, and our names were appearing till the point of time, my lord.
Yes.
Let me see. In that petition, madam, at page number 4, madam, it says, at this stage, this court finds it relevant to take note of Rule 4 of the Oil India Pension Fund, which categorically stipulates that the trustee shall decide all differences or disputes which may arise under the rules, either as to the interpretation thereof or as to the rights and obligations of the beneficiaries, and the decision of the trustees shall in all cases be final and binding on parties. Then Rule 4 is quoted, madam. And in terms of that, the petition was disposed of. But my lord, that is another lacuna.
Well, this is applicable in our case because the interpretation there is distinction between a temporary or a permanent employee. Here is a distinction between a trainee and an employee. So this is not applicable. That is correct. My senior is correct, but the only part is that any dispute has to be resolved by the trustees.
Okay, let's see. By next Friday, if you get anything, other employee, you tell us. We'll come to that. You are made a special group as a trainee.
My lord.
Basically. So, will you continue or remain after your successful completion of training until posts are available? You are inducted in those, whether it will be an employee of the All India Limited or Burma Oil Company Limited. That is the thing.
And I'll look into it, my lord. My lord, if I may request, my lord, that the respondents produce a copy of the erstwhile Burma Oil India Provident Pension Fund rules, my lord. We had submitted the RTI, but it was not given to us.
Is it required?
It is, my lord, because that is why where we enter into the erstwhile existing pension fund, my lord. That is also contention.
Mr. Kalita, find out in that particular scheme who are entitled or beneficiary of YPF. That's all.
The previous, my lord. The
Because
old
that
old
fund
Burma
was
Oil
created
India.
in the name of Burma Oil Company. Who was the beneficiaries? Because the date on which these petitioners, these are the trainee of Oil India Limited, so they are apparently not an employee, but whether in that time before the appointed day, the beneficiaries of such provident fund data was deducted or that under the OIPF, original BL, that is Burma Oil beneficiary. Find out what is the definition. What will be the beneficiaries? Whether trainees are given any beneficiaries. Right? Right. If it is there, tell us. Clarify. That extent. So if you Mr. Chaudhary, then on 8 you tell us regarding the employee and other employees. Anything? Anything else? From your end, you have completed. You have shown. We'll see.
I may give a list of these, my lord, so that the matter may be kept part of, my lord.
Will come on 8 to be there, no problem. But thing is this, you have to place something.
My lord,
Otherwise, you have seen. But Mr. Kolita, if it comes under that beneficiary is even the trainee is a beneficiary, because what we have seen during the period, of course. Mr. Chaudhary, just see when they have joined. There's because one list they have shown as 79. But I was surprised because the letters were given to them in 81 prior to the appointed date for the training. So that document that you have shown,
yes,
it was of 1,000 rupees.
Yes,
right. That was of 81. They were offered that training in the year 1981.
Yes.
Why there's documents of 1979? So
Understand.
there is something somewhere either from the part of, because these are all computerized type, but the offer of appointment was of training was of 1981.
Yes.
Just prior to the appointed date.
Yes.
Advertisement one issue that was of 1979, but the other one, that Khana Gogoi, who is the petitioners along the leading petitioner, there you have seen that his appointee training was of 1981. So there may be something
point of time.
that whether all the petitioners, these 12 petitioners, were offered training in some maybe in 1979,
Yes.
some maybe in 1981. Let's find out that.
My lord, if I may, I'll take a photocopy of the salary slip that I submitted.
Yes, is here somewhere.
I'll take a.
We'll keep a photocopy.
In fact, my lord, we do not have the copy of their.
I'll provide it. My seniors told me.
Publish. Publish only.
My lord, the petitioner, my lord.
GAD, right? Housing Urban.
Yes,
will
yes.
appear. GAD will appear.
This is
Or will appear.
my lord. This is House and Urban Affairs Department, my lord. I am appearing, my lord, but my lord, we wrote a letter, my lord, to the department. It's not forthcoming, my lord. My lord, my humble submission is, my lord will indicate if the instruction is not coming, my lord, personal appearance of the authority is called for, my lord. Because after 2-3 letters, my lord, if it doesn't come, it's not much worth, my lord, writing letters to them. We have written a very strong letter on 22nd 8 to the department. Still, it didn't come, my lord. Because the commissioner secretary has to respond, whatever it is, my lord. Unless the instructions comes in, it becomes very difficult to.
So, Mr. Todd, you admit that police rule will exist. Only when police rule is there, then you will be.
No, my lord. I will just.
I understood.
I will just show my
because-
lord the strong letter that my colleague has written. I was very surprised, my lord. Sometimes, my lord, I don't know. My lord will indicate if it's not forthcoming, then it becomes severe for us even sometime, my lord. Because the respondent number 7 has already filed an affidavit. In para 7, they have stated that MSCPS is now before the court of the government, that is the commissioner secretary. So unless they respond, my lord, what they have done after it is sent, that scheme in para 5, respondent number 7 has stated. These are minor, small issues has to be dealt with fast.
Page number 15. Petition 15 and 16. Assistant engineer, sound and country planning.
My lord, the affidavit filed by respondent number 7, this para 5, the government has to respond. Basically. By sir.
My lord, there was a specific query, my lord, as to the status of the inquiry report. That is order dated 31/7/23.
Next, the petitioner is a certificate accused. Special case number 02/2017. Presently, the trial is on. That is going. Pursuant to the order of the court. The responding authorities. Hold a review with regard to the suspension of the petition. As by notification dated 09/11/2016. Commissioner and Secretary, Government of Assam in the Urban Development Department suspended the petitioner with effect from the date of his arrest on 27/10/2016. Next, even after filing of the search sheet, as the petitioner was not registered in service, on his approach to the court by order dated 10/04/2019, passed in WPC number 4717/2018. After its review, the Commissioner Secretary on 05/11/2019. Commissioner Secretary. The Secretary Government of Assam, the Housing and Urban Affairs. Reads that the petitioner in service. Person to which joined his service on 06/11/2019 as an assistant engineer. Reason in such and such report. claim of the petitioner, take the prerogative for right to one query. Notice in this case was issued 18/05/2022. Accepting the director or deputy secretary. Only one has filed, right? Accepting the director of Town and Country Planning Assam, question number 7. And the Joint Secretary Government of Assam in the Housing and Urban Affairs Department. The other respondents have not filed their affidavits. Letter was written to whom, Mr. Dhar?
Then to Commissioner Secretary.
Housing and Urban.
Housing and Urban Department. Madam. On 2 occasions, one on 2/8/23 and 22/8/23.
On being inquired, the standing counsel.
Madam, I'm the additional senior government, as in government advocate. I'm
On being inquired, additional senior government advocate Assam submitted, though the Commissioner Secretary Government of Assam in the Housing and Urban Affairs Department has communicated more than 2 occasions, but as on date, no such instructions have been received from the end of the said authority. By an order dated 31/07/2023, the court specifically directed about the status of inquiry pertaining to disciplinary proceeding initiated against the petition submitted by the concerned inquiry officer and Joint Secretary Government of Assam on 16/01/2020. But neither the Commissioner Secretary Housing and Urban Affairs nor the Commissioner Secretary Town and Country Planning submitted the said report nor filed their affidavits. The said act of the respondents clearly reflects that they are obstructing judicial process pending before the court. List again on 25/09/2023. Failure on the part of the Commissioner Secretary in the Housing and Urban Affairs Department as well as, is there any secretary in Town and Country Planning or only the director?
Only director, madam. They comes under the department, so.
Filling on the portfolio. To file affidavit by the said authority. On or before 22. Such. Considering that the notice in this case was issued on 18/5/2022. The court shall consider to first consequential order against the erring respondent.
Obliged, madam.
May I please, your lordship? Your lordship, Mr. R. Pujari appears for this matter. He is in Legging Code 17, your lordship. Pass over the matter for the time being.
The finances filed their affidavit, my lord, the last occasion, but I don't know whether it's on record. But their stand is, my lord, is very limited because they have not said that they have not received any proposal from the, my lord, Food and Civil Supplies Department. But they were subsequently, my lord, asked to file an affidavit, my lord. Their affidavit, in fact, my lord, only, my lord, annexes that, my lord, adoption of the model rules. And, my lord, on the representations, my lord, the reply to our representations by which, my lord, our case was rejected with the Food and Civil Supply Department, was saying that we are not entitled. That, my lord, of course, is also part of the affidavit of the, my lord, Civil Supplies Department. That representation is.
Members are presented, appointed under basis of some selection.
Yes, my lord.
The advertisement.
Yes, my advertisement is made, my lord.
Where is that advertisement?
Advertisement, my lord. Our advertisement, of course, we did not, my lord, keep the advertisement by which we were, my lord, appointed, but we have similar advertisement at page 22, my lord, annexure 1.
Of your repetition?
Yes, my lord. We'll show, my lord, that there are two advertisements, the subsequent advertisements, my lord, also of similar nature. Only, my lord, some minor changes, my lord, but the basic nature, my lord, basic, my lord, qualifications, etc., all the same, my lord. Now the tenure, my lord, has become 4 years. Earlier the tenure used to be 5 years. In fact, my lord, some of the petitioners, my lord, they have their tenure has ended in the month of June, my lord.
What is about the remuneration?
Remuneration, lordship will find, my lord.
600 plus 150.
Yes, my lord, 600, 150.
So if you have applied pursuant to the advertisement.
Yes, ma'am.
Will you be able to draw any salary?
So what has happened, our cases, my lord, when subsequent the new rules have come in, my lord, we are discharging similar functions, my lord, as the newly appointed persons, my lord. Our appointments were prior to the coming of the new rules, my lord. When, my lord, we were appointed, these rules were not there. In 2019, after the amendment of the Consumer Protection Act, my lord, a new rule has been, my lord, brought in, my lord. And, my lord, the state is yet to bring its own rules. It was the direction of the Supreme Court, my lord, that if the state doesn't bring its rule, my lord, it has to follow the model rules by the central government, my lord. As per that model rules, my lord, the present members who are, my lord, appointed under the new rule, my lord, they are receiving salaries of deputy secretary rank, my lord. But so for the petitioners concerned, they are receiving this, my lord, salary of 650 plus 600 plus 150 per day. And, my lord, the functions, etc., everything else, my lord, even the qualification, my lord, are all same, my lord. The responsibilities, the duties, my lord, they sit together, my lord, they deliver the judgments together, my lord. They form the quorum of the bench, my lord. Everything, every way, my lord, sense, my lord, responsibilities, my lord, liabilities, my lord, their duties towards the job, my lord, everything is similar, my lord. Now, my lord, before these rules came in, my lord, after these rules,
are appearing for finance.
Your lordship, Mr. R. Pujari appears. He is in Legs and Code 17, your lordship.
Who is appearing for Food and Civil Service Department? Who is appearing for Food and Civil Service? Get hold of. Wait for some. Mr. Doctor, wait for some.
My lord, my lord.
Oh, Mr. Bapuja, you are here.
Do we have filed an affidavit here, my lord?
No, you are appearing for
the finance department.
Finance. Let Mr. Dhar come because consumer is important.
Because main stand they've taken. The finance is only saying that we have no proposal been received by us.
Proposal received, my lord, and it is within the domain of, my lord, Food and Civil Supplies Department, my lord.
Let us see.
My lord, I am obliged.
Well.
Yes, Mr. Chaudhary.
My lord, in this case, my lord, the state has filed an affidavit. Basically, my lord, it's a transfer matter, my lord, the second round of litigation. My lord, I need to file a response to that affidavit, my lord. I need a week's time, my lord.
Where is the transfer order?
But the first order is at page 36, my lord. Lordship has got it, my lord. My lord, my name is at serial number 3. From Disney Revenue Circle to Boroma Revenue Circle. And the private respondent, my lord, at serial number 4, he was transferred from Boroma to Disney. My lord, this was put to challenge. My lord, in the writ petition, my lord, which your lordship will find at page number 38. In WPC number 6607 of 2022.
What happened?
Page 38, my lord. And that order starts at page 39. And the operative portion, lordship will find at paragraph 5 of the next page, my lord, page number 14. May I read, my lord? Considering the matter in its entirety, we require the petitioner to submit a fresh comprehensive representation within a period of 3 days from the date upon which the representation being submitted. The Director of Land Records and Survey BTC Corporation shall pass, that is important, a reasoned order on the representation within another 15 days thereafter from the date of submission of the representation. Till date, till such order is passed, the director an order of status quo maintained as regards the transfer of the petitioner vis-a-vis the respondent number 7 by the order implemented so and so. But the direction of this honorable court was to pass a reasoned order on the basis of representation submitted by the petitioner. If your lordship turns to page 41, a detailed representation with all the facts, my lord, was placed before the Director of Land Records. But, my lord, the order impugned does not reflect anything on the representation passed, my lord. That is the sole one of the grounds, my lord. On the page 44, it is seen that only pursuant to the endorsement, by the order, lordship has got to page 44, which, but it is nothing reflected. Only thing is that whereas the pursuant to the endorsement from Honorable Executive Member Land Revenue and DM Department BTC issued by memo number so and so, an order was issued by DLR Surveys BTC transferring Abhiram Das Latmandal from BSD Revenue Circle to Baksa. Whereas that is the, my lord, sub and substance. Whereas the Abhiram Das has preferred a writ petition before the Honorable Guwahati High Court, and the Honorable High Court by its order dated 29/9/2022 in WPC number 7 so issued an order of status quo to be maintained as regard the transfer of Sri Abhiram Das and directed the Director of Land Records and Survey BTC to pass a reasoned order on the representation to be made by Sri Abhiram Das on withdrawal of his transfer order. Whereas Sri Abhiram Das Latmandal BSD Revenue Circle has submitted a representation on 30/9/2022 before the Director of Land Records and Survey BTC requesting him for withdrawal of the transfer order dated 26/9/2023. That is important. Whereas the Circle Officer BSD Revenue Circle by number BC3 so and so dated 1/10/2022 has submitted that Sri Abhiram Das Latmandal has joined BSD Revenue Circle on 5/6/2007. Though he was transferred to Sidley Revenue Circle on 2/3/2020 and was released from Business Revenue Circle on 6/3/2020. The transfer order was cancelled on 6/3/2020. The incumbent joined at Business Revenue Circle on 7/3/2020. The incumbent did not join Sydney Revenue Circle. Thus, he has been continuously in Business Revenue Circle since 5/6/2007. But there is no whisper about the representation as mandated by this honorable court. Lordship, I turn to page 40 again, my lord. The specific direction, considering the matter in its entirety, we require the petitioner to submit a fresh comprehensive representation within a period of 3 days from today. And upon the representation being submitted, the Director of Land Records and Survey, BTC Kukrajar, shall pass a revision order on the representation within another 15 days. So no whisper about my lord, the reasons for not transferring the petitioner in the order. In the most mechanical way, my lord, that order has been passed, that has been put to challenge, and by this court, by an interim order, has stayed the transfer order, my lord. And private respondent has filed affidavit. We have filed our response. The BTC authorities has filed an affidavit, my lord. I need to respond to that now.
Since when you are in business?
As per this, my lord, I am in business since 2007. In between,
how long you want to continue?
No,
Tell us very frankly, till how long you want to continue?
Because
you are in a government servant, right?
Yes.
And transfer is in exigency of service.
Yes.
Right. Now you are aware that you are in a transferable post.
Yes.
Right.
Transferable post, that is, my lord, within the district. For inter-district transfer for Mandal, but there is a judgment of this honorable court also, my lord, Justice Ujjwal Bhuia's judgment, which says that, my lord, inter-district transfer in case of Lat Mandal is to be exercised only in special cases with reasoned orders. That post is also not. Well, although I was in Business Revenue Circle, my lot was changed from time to time. It is not that I was allotted the same lot. But that things I want to bring on record, my lord.
Okay.
In response to the affidavit filed by the BTC. And in fact, Lordship may turn to page the impugned order once again, my lord. Here, my lord, reference was made. They justified the transfer order of 26/9/2022 by relying on an order of 1/10/2022. While the initial order, they just validated the initial order. But when that initial order of 29/6/2022 was issued, that circle officer report was also not there. Lordship, one more aspect, Lordship may like to look into, my lord. Lordship may turn to page 33 for a moment, my lord. Lordship may turn to page 33 for a moment. That is the type copy, my lord. This was issued by the Deputy Commissioner of Bongaigaon to the Principal Secretary of BTC way back in 2016. May I read, my lord?
Yes, please.
Transferring of post of Latmandal from establishment of BTC to DC's establishment Bongaigaon. With reference to the subject cited above, I have the honor to inform you that Government of Assam has accorded sanction for creation of Manipur Revenue Circle by notification number RLR so and so
dated 3/3/2016, and function of it will be started within a short time. Sri Akhil Kumar Roy and 2 other Latmandals. Here, my lord, the petitioner is also one of them, my lord. Functioning amongst most of the villages under the lot of Bizni, part of Bongaigaon district, and they have prayed for inclusion of their names in the gradation list of Latmandal, Bongaigaon district. In view of above, you are requested to take necessary steps for transferring 3 posts of Latmandal from BTC establishment to the establishment of DC Bongaigaon within 10 days, so that gradation list of LR staff Bongaigaon district may be finalized in a short time. But a specific request was made by the Deputy Commissioner. But to that, my lord, the BTC authorities responded at page 35, my lord. That was issued, my lord, from the BTC authority to Director of Land Record. Enclosed herewith, please find the photocopies of request letter from the Deputy Commissioner Bongaigaon in respect of inter-district transfer of 3 lot mandals of Bizni Revenue Circle, Bizni of BTC area, which speaks for itself. As regards to the petition, BTC authority has no objection in respect of transferring from Bizni Revenue Circle to the establishment of Bongaigaon without post. Copy is also marked, my lord, at serial number 6, Akhil Kumar Roy, Bhaskar Roy, and Abhiram Das. Abhiram Das is also the petitioner here, my lord. Now, what I am trying to project, my lord, in respect of inter-district transfer of mandals, in other cases, my lord, state has the prerogative of transferring from any person to any other place, my lord. So when it is a inter-district transfer of a lot mandal, but some procedure has to be established, my lord. And apart from that, my lord, that process of transferring the petitioner from Bizni to Bongaigaon is also presently going on. If at this moment, my lord, petitioner is transferred from a position to other place, it will be difficult, my lord.
If they consider, he'll go back. That's all, because it's a letter of the commissioner and others, right?
Yes.
It's written between the principal secretary or BTC and the whoever it is communicated, deputy commissioner or what?
Regarding the affidavit, they have said that 15 years taken together, but not in the same document. I'll bring on record the lots which were allotted during this period, my lord.
Who is appearing for BTC?
Sir, I'm on behalf of RTC National Court Lordship. It's not well today.
Who is appearing for respondent number 7? Since when you are at Boroma? Since when you are at Boroma? Tell us, since when you are at Boroma? Mr. Hendik, there for the purpose of transfer of one Latmondal from one district to another district, the director of land records have to consider what? Is there any? Really, the lots can be changed, right? From one lot to another lot, the Latmondal can be placed within that district. Now, if it is an inter-district transfer, what is the stage?
Inter-district transfer, my lord, that the lot will be the, my lord, there is no lot, my lord, there can be, my lord.
If it is inter-district, because in the case in hand,
Lordship.
the petitioner has been transferred to Boroma
Lordship.
from Bizni.
Boroma, Lordship. My lord, this is the, my lord, that within the, my lord, that BTC area, my lord, that.
That's true. That is why we're asking you. This is a district transfer. So
From Chirang to Baskamai.
Sorry, Chirang to Baksa. Right. Now, in the case of any such district transfer of a Latmondal, what is the procedure?
See, my lord, that I have to take instruction, my lord, that my lord, transfer, my lord, that can be, my lord.
If it is within the law, within the district, it is different. But if
Lordship.
it is inter-district, then what is the stage?
Inter-district normally, my lord, that the lot is will be the same, my lord, only the person, my lord, who was working on the, my lord, that my lord area, my lord, he can be sent.
Let us assume a particular Latmondal is serving at Shivsagar.
Lordship.
There will be many lots.
Many lots.
Many revenue circles.
Many revenue circles.
Now that person from Shivsagar has been transferred to Sonitpur.
Lordship.
What is the procedure? Because the Latmondal is under a particular district commission.
The particular that post, my lord, will be should be, my lord, the vacant, or my lord, that person should be transferred to the other person, my lord. That when the one person is transferred to the another district, lordship, that person also should be the transferred to the some other place. Lordship.
Perhaps, my lord, on mutual transfer, my lord, it can be done, but instant case is not a case where petitioner and the private respondent has wanted mutual transfer, my lord.
Well, that is not there, my lord, in the, my lord, that person who was, my lord, they're serving in the, my lord, the government job, my lord, they have to be transferred to the some other place. It is not that, my lord, that he cannot be stay in the same, my lord, station for a long time, lordship.
Since when you were at Borama?
I just took instruction more than 1 year.
So why do you need to be transferred?
My lord.
Why do you need to be transferred to only because the petitioner has served for more than 15 years?
So, my lord, I am nowhere involved, my lord. I have been made a party, my lord, by them, my lord. So I am appearing, I have my affidavit, my lord. There was some allegation that this.
Prior to joining at Borama, where you were?
Prior to Borama, my lord, that instruction I don't have. I can take my.
Where is the standing council BTC? Will be appearing. Will be appearing.
She told me that he's not feeling well, my lord, that, and the second half, my lord, he told me.
Who appeared?
My lord, the RB Bora was.
On the next date fixed, the Director of Land Records and Surveys, BTC Koprajar, shall apprise the court as to where, since by which order the respond number 7, Bigrai Musahari Latmandal was appointed and posted, appointed/posted at Boroma Revenue Circle. Further, prior to the posting of the respond number 7, at Boroma Revenue Circle, the said respondent, the place of posting of the said respondent number 7, an order of such posting therein. Next week. In addition to the above, the DLR and surveys, DLR and SVLI, BTC, Koprajar shall also apprised. About such lot mandals serving in the districts of Chirang, Koprajar, Baksa, and Udalguri. For more than 10 years. Based on (27th). The petitioner shall file his reply. The affidavit of DLRS Koprajar filed on 02/06/2023. 2009 2023. Oh, yes. I mean,
Interim order.
yes, Mr. Dhar, are you there? Mr. Dhar, one thing on instruction we are looking forward from you. The matter is presently pending before the Honorable Apex Court. And the Consumer Affairs Department is also appointing the members and the information.
Item number 24, Madam.
But there is an observation in that Honorable Apex Court that if you do not frame the rules, you have to follow the rules specified by the central government. As per the rules of the central government, salaries are paid to the members, but wherein the state of Assam, you are paying only 500 plus 150 remuneration. So, as the state, though the rules, the law came in 2020, but the act came in 2020. We have not, as on date, there is no rules. We have not framed any rules as such. Will any such member will not be entitled for any such salary on?
My lord, we have filed our affidavit in this.
You have seen that?
Yes, my lord. Now the here the thing is that, my lord, the very inception, they were appointed not under the new rules, my lord, that we have adopted the model rules, but they were not appointed, my lord. So for that, my lord, again we'll appoint them. Let them resign.
Are you paying salaries to the members who are appointed subsequently under the 2020 rules? Are you paying?
My lord, we are paying. My lord will come to page 70 of my affidavit. That is the.
How much you are paying? 500 plus 150?
Exactly, my lord. Because that is the. They were appointed.
In the advertisement that you are making after 2020, what is the payment to be made to the members?
The current, my lord, that I will find, my lord. Because in my affidavit doesn't cover.
Find out.
My lord.
Tell us next day.
My lord.
If it is a case that the petitioners have been appointed prior to the rule 2020 Act,
my lord,
came into force.
My lord.
So that is why they have been paid the remuneration of 500 plus
My lord.
150. Now, if you are paying someone 2020 after,
we'll have to, my lord, see that how they were after adopting the new rules, my lord, the model rules that we have adopted, whether the new incumbent they were appointed under which rules. If, my lord, if it is prior to this adoption of the rule, my lord,
that will be considered. The only grievances of the petitioners are that they are rendering similar service
my lord,
as to that of their counterparts in that particular board
my lord,
commission. So why they are not entitled for that amount?
my lord.
Tell us
On
on the next date.
my lord. My lord, pass an order. I will.
We are fixing it on 14th.
My lord. 14th.
On the next date, 5th. The respondents in the Food and Civil Supplies and Consumer Affairs Department shall apprise the post whether the new members appointed under the 2020 Act are receiving salaries in terms of the central government rules or receiving remuneration just like the petitioners.
Also, here the petitioner has received the salary loss.
Hey Islam, right? Your good name?
ALM Escalot.
Counsel for the petition. And Sharma, Standing Counsel, Department of School Education. Elementary.
All the respondents.
For the respondent, for all the official respondents. Matter pertains to non-payment of arrears salary to the petitioner with effect from 1/1/2021. During the deliberation of the matter, after resolution, after provincial level service. Where is the provincialization order?
It is not annexed with the.
It is not annexed plots, but a statement is here. 5/2/2021 lots.
Displayed before the court by Mr. Sharma. A communication dated 31/08/2023 of the Director of Elementary Education Assam. Where the petitioner has been paid his arrear salary. Arrear fixed pay or salary?
Fixed pay.
You're appointed as a tutor.
Tutor.
Appointed arts tutor or science teacher?
Arts tutor.
Language?
Yes, sir.
Fixed pay. As a tutor, language, as a tutor, within bracket language, at Mayer Shore Public ME Madrasa. For the period from 01/01/2022.
2021 lawsuit. 01/01/2021
to 28/02/2023.
lawsuit.
Amounting to rupees 2,80,592. Credited in the bank account of the petitioner on 06/06/2023. Which has been accepted by the petitioner. Learned counsel appearing for the petitioner. It is also been placed, it is also placed that the fixed salary of the petitioner has also, for the month of March, has also been credited in the bank account of the petitioner on 18/4/2023. These facts have been accepted by the Land Council for the petition. This petition, the was stands disposed of. Business disposed of. Copy of the communication of the Director of Relevant Education Assam dated 31/08/2023 be kept in the part of.
Okay.